And I'll be presenting the cases on the public hearing today. At this time, I'd ask everyone to please turn your phone off or silence your cell phone. Matters on public hearing today will be, we will review site plans that have been submitted by the applicants, as well as photographs and maps of the subject properties, letters that we've received in support or opposition, as well as any correspondence from other government agencies are maintained as part of the case file and have been provided to the board members for review. At the conclusion of the staff's presentation, the appellant will have an opportunity to present their case to the board, as well as anyone who's present in support of the application. If there's anyone here in opposition to a matter, then the board will hear from those parties as well. After the opposition has presented their testimony, the appellant may have an opportunity to rebut the opposition testimony. Pursuant to the board rules, an appellant who does not have opposition present will have 5 minutes to present their case to the board. In contested cases, the board will provide 10 minutes for each side to present their case. And if appellant should wish to provide rebuttal testimony after the opposition has presented their testimony, then the appellant would need to reserve some of their allotted time. All section numbers that we refer to today come directly from the Metropolitan Zoning Code as adopted by the Metro Council. These proceedings are recorded, so it's imperative that everyone, when you come forward to speak to the board, please speak into the microphone and first state your name and your address for the board, and then make your presentation. Please note that providing false or misleading testimony to the board may result in the revocation of your permit after a show cause hearing. The board will go through all cases set for public hearing today. After each case, the board will discuss and vote on that case. The Metro Zoning Code requires 4 affirmative votes to grant an application. If all board members are not present and the board does not reach a consensus today, your case will appear back on the board's next docket. Applications that fail to receive 4 affirmative votes at 2 consecutive meetings shall be denied by operational law. The appellant or other interested party may request a rehearing by the board within 60 days after the decision of the case. Parties may also appeal the board's decision to the Davidson County Chancery Court by filing a writ of certiorari within 60 days. All parties are encouraged to seek independent legal counsel regarding the filing of appeal to ensure that all deadlines and procedures are followed. If you're an appellant and your case is granted, it will be necessary to obtain the permit for which you have applied. So please note that the permit must be obtained no more than 2 years after this board's decision. At this time, I would like to go through the consent agenda. A board member reviews the record in each case prior to the hearing, and if in their opinion the appellant meets the criteria for the application requested, and they feel testimony in this case would not alter the material facts, the case is recommended to the board for approval. We'll call the consent agenda at this time for cases that have been recommended for approval, and if there's anyone opposed to one of those cases, please raise your hand, and the case will be removed from the consent agenda and heard in its regular order on the docket. The items proposed for consent agenda today are case number 2022-040. I wanted to read the caption of that matter. That is a request to add a second story to a non-conforming residential structure located at 811 South 12th Street. Case number 2022-045.
I want to see if anybody's here in opposition to 040.
Okay.
Yeah.
Is anyone here in opposition to case 2022-040, a request to add a second story to a non-conforming structure at 811 South 12th Street?
Or, sir, are you in opposition to it, or were you just, okay, all right, okay.
Okay, seeing one, the next case on our consent agenda today, case 2022-045. Is a request for a street and side street setback variances to permit an illuminated street sign for property located at 1700 Pearl Street. Is anyone here in opposition to that case? An illuminated sign at 1200 Pearl, 1700 Pearl, I'm sorry. Okay, I don't see anyone in opposition on that one. Case number 2022-46. This is a request for a street setback variance for property located at 6216 Robin Hill Road. Is anyone here on that matter in opposition? I don't see anyone here in opposition to that one. On case 2022-49, this is a request for a variance from the parking requirements for properties located at 1816A and 1816B Allison Place. Is anyone here in opposition to that matter? Seeing no one, I would ask for the board to move approval of the items on the consent agenda, please.
Okay, Mr. Wallace has made a motion. Is there a second?
Second.
There's a second. All in favor of approving the items on the consent agenda? Aye. No one opposed.
Okay, so for those appellants who are here, or the applicants who are here for the items that just got adopted on the consent agenda, you're free to go at this time. Please give our staff a few days to process the documentation associated with your request that's been granted, after which you can come into the office and pursue the permits for which you have applied. We have one council member present here today, Councilman Pulley. Are there any other council members present? I don't see any. Councilman Pulley, would you like to be heard at this time, or would you prefer to wait until the matter is called? At this time, Councilman Pulley will be heard. I believe you're here on the matter at 2402 Valley Brook Drive. Oh, and then you're also here on 923. Okay. I'd be happy to go through those items on the agenda if you'd like me to.
It's up to you. 042 and
Okay, thank you, Councilman Pulley. I'll just read those items on the agenda really quickly. Case number 2021-31 is a request for a variance from the street setback for property located at 2402 Valley Brook Road in the RS40 zoning district. Case 2022-042, was that correct?
yes, ma'am.
That was a request for a variance from the street setback requirement for a single-family dwelling at 4421 Lone Oak Drive. And case 2022-50 is an item A appeal of the zoning administrator's interpretation of the street setback requirements for property located at 923 Sutton Hill Road in the RS10 zoning district.
Thank you, Ms. Waits. I appreciate that very much. Good to see you all. Thank you for hearing me. First, I'm just going to very briefly remind you of my position on 2022-031. I spoke the last meeting or the previous meeting, and this was ultimately deferred. I just want to reiterate that my position is unchanged, that I do not support the request for this variance for the reasons stated previously. I will just leave it at that unless you would like to hear me go through that diatribe again. Absent that, absent any request to do that, I'll speak very briefly on 2022-042, and I'll state that I have had a number of conversations with the appellant about this, and in my initial conversations with him, I encouraged neighborhood engagement so that he can involve the neighbors in what it is that he's going to do and why he wants to do it. And my understanding is that has occurred, and there is a bit of neighborhood support for this, although one neighbor had sent in a letter of opposition. My understanding of this request, my understanding is it doesn't put him outside of any his request doesn't put him outside of any contextual line issues, and the one thing that a lot of my constituents do like, which will result from this, is in many cases these variances are done to increase density, and in this situation it'd be the opposite. There'll be one house going up instead of two, and people in my district tend to like that. So I'm not going to take a position. I'm certainly not for or against. I will leave that to your good judgment. appellant, and I appreciate very much what you do. The last item, when I appeared before you last, I did bring up the fact that this issue was on the horizon, and I've dealt with this on a number of occasions in my district. This deals with an exception to the contextual line that's written into a 2014 ordinance, which does establish contextual lines. And having done a little bit of research on that ordinance, because this issue has come up a number of times in my district, the ordinance was created by Jason Holland back in 2014 to establish contextual lines, it being the end of his term and receiving a little bit of opposition from the development community. The exception of 3 times the mandatory minimum setback as a maximum for the zoning administrator to consider was put in this ordinance basically to acquiesce to a little bit of resistance that he received from the development community in order to get this passed at the end of his term. So it is there, and it's something for you to consider. It's something we can't ignore. What I will tell you is the consequence of this is we are seeing a number of houses that are built to this maximum setback, which are significantly in front of contextual lines, which is not what this was really intended to do. So I'm currently working on a legislative solution to this, but again, that's not yet been not yet come to fruition. So I just want you to consider that as you guys deliberate what you hear from this and future appellants who are neighbors who will come seeking some relief from the Board of Zoning Appeals for this. I just want you to know that it has become an issue, and I'm working on a solution, and I leave that for you to, I just want to advocate for that position as you guys deliberate. So thank you very much for what you do. I appreciate you as always, and with that, I'll let you get to your work.
Thank you, Councilman.
Okay, at this time, we will start calling through items that are on the docket. The first item is case 2022-19. This is a request for a variance from the zoning conditions for constructing 2-family dwellings for properties located at 3982 and 3978 Taylor Road in the R6 zoning district. Under Metro Code of Laws 17-16-030-D1, in order to qualify for construction of 2-family dwellings on each parcel, the property must have been legally established before August 1, 1984, either by plat or by deed. This property was established by deed, so there's no plat in this subdivision. After city-county consolidation, the Metro Planning Commission adopted subdivision regulations in 1964, after which date any properties established by deed must have complied with the Metropolitan subdivision regulations, which required any subdivided tract to originate from a tract that had at least 3 acres. On our slide presentations, here we have the zoning map of this property, as well as the aerial photo. Here's a picture of the current condition of the lot. This is vacant, unimproved property. In your packet, you will see there's been a title search document showing how these parcels were divided. Is anyone here in opposition to this case? Seeing none, the applicant will have 5 minutes to make a presentation.
So to summarize, the position of the zoning administrator is this was illegally subdivided?
That's correct. I'll defer. I'll defer to the zoning
It was
administrator.
because the tracts from what we could find in title search were created post 1964. It would have required a subdivision plat. So because they're illegally subdivided, they're not eligible for two-family dwellings. So the applicant, Mr. Brain, that's here, originally filed this as an item A. He's no longer takes that position, but he's asking you all for a variance from the conditions under the PC section there in 17-16-030D.
So this is coming to us as a variance?
As a variance request, yes, sir.
Good afternoon, Cleveland Bain, 1222 16th Avenue South. I represent Suburban Cowboys. They're the owners of this property. As Mr. Hargis laid out, they approached the zoning staff to get a permit to build 2 duplexes on each individual lot. And when it was discovered about this subdivision, it appears that happened sometime in the 70s. I have done some research. I've tried to see if anything was submitted to the Planning Commission, and I couldn't find anything. And of course, we don't know what happened back in the 70s, if they approached staff or anything like that. What's unique about this property is, like, we have the base zoning, so we're not asking for like a use variance, which the board would not be permitted to give under the code. What we're requesting is a variance from one of the conditions, and that's the 1984 condition. And the reason why we can do that, or believe that we can do that, is under the review standards, there's the topographical issues, but there's also like an exceptional or undue hardship to the owner, which is what I would be traveling on under this variance request.
So you're saying you're asking for a variance from the 1984 condition, which is the
Legally permitted lot prior to August of 80.
So can we, I mean, I understand we can grant a variance based on conditions of the property, but I don't, do you think we have the authority to grant an, it seems to me like you're asking for an exception and not a variance.
It's kind of a hybrid of both, but the reason why I believe the board can do that is because in 1740-340, it establishes what the board cannot grant variances on, and it enumerates what you cannot grant a variance on. The ordinance on which we rely on, which is the 1716-030D, is not listed on that. Now, 1716-030F is listed on there. Ergo, I would take the position, since it's not enumerated, that the board cannot grant a variance, then you can.
Okay. Do you have a position on that, Mr. Hargis?
No, I agree with the appellant in that case, that the board does have specific carve-outs of what it cannot do. Given that the same standard applies for a hardship as any other variance, so.
Okay.
Textualist.
And I would point out to the board that this would not be unique if you were to grant this. The very adjacent neighboring property has a duplex on it. This would actually match the base zoning. We would kind of be the anomaly as this area develops and gentrifies. You're going to have duplex, single family duplex. So this would actually be more in line and in more continuity with the base zoning and the overall plan for that area. It's not a hardship that was self-imposed. We didn't do this. This happened decades and decades ago. Financial gain is not the only basis. While it may be a part of it, a greater portion of this request is the continuity with the rest of the neighborhood. So we are not the anomaly on the street. There's no injury to the neighboring property, and there's no harm to the public welfare. I would actually say, with the housing shortages, single-family housing shortages we have in Nashville right now, it would actually be a benefit to the public welfare. So going through those review standards as set forth in the ordinance, I believe the applicants meet the standards and the requirements, and a variance for this condition would be proper in this situation.
There's no opposition that I saw. Is that accurate? Okay.
There's no opposition, and I've spoken with the council person via telephone and email on this as well.
Okay. Any questions for Mr. Bain? Okay, we'll close the public hearing and discuss. Thank you.
Mr. Hargis, so correct me if I'm wrong, but it looked like from what I saw on there a moment ago on the screen, and what I'm seeing on Parcel Viewer shows us as two properties. So it's kind of, until maybe you dug in the details, for the last 50 years, Metro has assumed this to be essentially two properties, even though it wasn't officially maybe recorded. Is that fair to say?
That is fair to say. The mapping division that maintains our property maps will map illegal subdivisions. The tax assessor will take taxes, assess taxes on illegal subdivisions.
May I address the question? So they had separate ownership.
Okay.
So these parcels have not been combined until recently.
Okay.
Yeah.
Gotcha.
They started out as a single parcel in the 40s, went their separate ways, and now they are joining parcels that
Okay.
are owned by a common owner.
Yeah, and part of the deed search, because I looked at the northernmost parcel, the larger that has the duplex on it, it was actually carved out of this transaction. These two pieces were sort of the remainder of that deed transaction. Unfortunately, as we learned in property law, if bad is the one, bad is the all. So the illegal subdivision that created out of that, if this board grants this request, the applicant still has to file a subdivision plat with the Planning Commission to plat these parcels. So I don't want to harbor on the subdivision aspect of it, because it's not in front of you. But
Yeah.
I mean,
But it helps to understand kind of how this has been viewed for the last 50 years.
Right.
Essentially.
and for, I guess for the public at large that watches this, we get thousands of calls a month over, can I build on this lot? Can I build on this lot? There are numbers of these parcels that were created not the correct way.
When I saw your look.
Yes, no, I mean, even when, it goes back hundreds, at least goes back to 1964 is where we look.
Well, it matches the base zoning, which is really significant to me, and there's no objection. And also think Mr. Bain makes a good point about, it does help with more affordable housing. I'm glad, we learn something every meeting, but I was wondering whether we had authority. I always thought it had to do just with the property, so I'm glad Mr. Hardy's educated me about that.
I think you have the authority. Whether you should, that's a different question, or whether they meet the hardship standard is a different question.
That's good enough for me.
It is not a situation in which, if this board were to grant this, that I would turn to my counsel here and ask them to pursue legal. I'm not willing to make a fight over it, but.
Yeah, well, I mean, I am familiar with this area, and it's kind of a weird area that is, it's really, half of it's never really been built. It's kind of like some weird spots of lots that they've never been built on, and then some that have been torn down and rebuilt, and it really is in a state of flux right now, and it's not like you're coming into existing context and just kind of like the applicant said, just doing something completely different than what's been done there before. So it's really a strange development pattern in this particular area of town.
Mm-hmm.
So
Yeah, I mean, it's got houses.
mm-hmm. So there's like.
So was that a wind up for a motion?
So I'll make a motion. Yeah, I guess so. Yeah, I'll make a motion that we approve the variance based on the undue hardship as noted by the applicant.
I second it.
Okay, we have a motion and a second. All in favor, say aye. Any opposed? Okay, that passes. Thank you, Mr. Bain.
As always, thank you, members of the board. Y'all have a good afternoon.
Next item on our agenda is case 2022-030. This is a request for a street setback variance for two commonly owned parcels located at 625 and 637 Claridge Drive in the R10 zoning district. The property owner who conveyed these parcels accepted a TVA easement on one of these lots in 1987. And the other lot was purchased by the same owners from NES in 2000, which was an unimproved property containing a stormwater easement. The contextual setback is 48.25 feet. The platted minimum setback is 30 feet, and this item was deferred from April 7th. On our slides, we have the zoning map of the neighborhood, as well as a contour map of the slope topography. Here we have photos showing the current condition of this property. 637 Claridge is also known as Lot 25. That's where the TVA easement is. 625 Claridge is known as Lot 27, and that's the one with the stormwater easement. Here's the properties as they exist today. This is 637 that has the TVA. 625. This is a LiDAR image map created by the Metro Planning Department in 2016, and it shows the location of the stormwater ditch at the time that the image was created. We have a copy of the sealed survey of the lots that was presented from February of this year, showing the stormwater ditch running roughly parallel to the side property lines on Lot 27. And we would also like to note that the survey was created without any reference to the site plan. Before you hear are renderings of the site plan drafted onto the survey and purporting an approximate 45-degree rear drainage easement along Lot 27. This slide is a blown-up image of the site plan that's being requested, which would be for a 20-foot setback on Lot 25 with the TVA easement and a 30-foot setback to be approved along the Lot 27 with the stormwater easement. And then finally here, there was an alternate rendering submitted for the board to see drawings upon the survey if it was a 30-foot setback granted on Lot 25, as well as a rendering of the contextual setback for Lot 27. So I'll return the slide for now back to the site plan that's been requested. Are there any parties here in opposition to this matter? Seeing none, the applicant may come forward. And you'll have 5 minutes to make your presentation. Please state your name at the beginning of your presentation and address.
Hi, everybody. My name is Brian Musser. This is Josh Helmer. Appreciate your time and your patience with us. We were here 4 weeks ago. As a quick summary, we had requested you guys had requested more information pertaining to the hardships that we were experiencing at these two properties. So Lot 27 has a stormwater drainage easement that cuts through their property and reduces buildable space. What you all had asked is for the surveyor to mark on the survey where that stormwater easement affects us.
And is this the latest survey you submitted? Did the surveyor do that?
Yes, sir.
Okay.
So what you're looking at on the screen there on Lot 27, you see, and the LiDAR was a great example of reaffirming this survey. The topography runs high on the north side, low on the south side, and it also runs west to east. So the water drains from the top down there sort of to the back corner of the house, and then it goes to the southeast corner. So it cuts off that lot.
Let me go back to the surveyor and ask you these questions. Originally, you submitted a survey that the surveyor signed on February 22nd, 2022, and it does not show a drainage easement, except on not this one. It shows one going down the left. Then you submitted another one, and I looked at it carefully, and it has the same date on it. It has the date of February 22nd, 2022, and the very same signature, and it shows a totally different drainage easement. Is that something the surveyor did on the same day? And can you explain that? Because I don't understand it.
No, he did it for us after the request. I think what was happening was when we came here, we were unable to show the actual conditions, and so they went out there and did the actual conditions and drew that one. I don't know why he didn't change the date or put a revision mark, but the email that I sent that I think was in here Might have been a direct email from him, so it should have the date that they drew it.
So he just used the same survey, same date, same signature, and superimposed this, and also found on the very bottom in very small type, it says 2/23/22 V2 per owner comments. So what does that mean?
Right here.
Yeah, I'm not really sure. Version 2 per owner comments.
We asked the surveyor to go out and mark where that stormwater easement runs, basically east to west there. I think what that small comment 2/23/22 version 2 per owner comments refers to is our request for him to go out there and mark that.
Well, that would have been 2 months before we were in front of this board, so I'm not sure what that is.
I just wanted that clarified for the record, because I think it's unusual for a surveyor to to do this. But I mean, if you're saying the surveyor took the original survey, didn't stamp and file it again, and just change the drainage ditch. I mean, because it's not showing the original public utilities and drainage easement that it showed down the left. So that went all the way down the property, so now that's gone. I'm just, if the surveyor did that, I just want to make sure that's what happened, because it looks strange.
Yeah, so we received this survey from him on April 13th. The original...
Recent one?
Correct, yep. Okay. The original email that he sent to us in February, I believe, was just using the drainage easement from the Register of Deeds. And then when we came to see you guys, we were explaining the field conditions, and they didn't match the Register of Deeds easement. So he went out there and actually mapped it and drew it properly.
Okay, thanks. Thank you for that clarification.
No problem at all.
It was confusing to me when I looked at it.
Yeah, I'm not really sure why he didn't put a revision date on there.
I had a question for you guys, just as I've kind of looked at the plans and want to make sure I understand. So did essentially this was all one lot, and then this was subdivided, for you guys to kind of buy the side lots? Is that what happened there?
Yes,
yeah,
sir.
there was underlying lot lines that were reinstated.
Okay.
Because we're kind of changing what we're asking for.
Yeah, go ahead, take it.
You can tell them.
So what we're asking for is the 30-foot setback on lot 27. Y'all can see where the stormwater easement cuts in the back of the property. And then on lot 25, we're asking for 20 feet. That TVA easement, it's high tension lines in the back that has a significant radius that they need to get heavy equipment back there to work on those lines.
Last time we asked if you could bring some pictures of the ditch. I did not see any of those, but I may have missed them because we had a really lengthy packet.
Yeah, so we tried to, and we couldn't really get anything from the ground. And then as soon as we put a drone in the air, we weren't able to get up in the air because of the airport. It restricts you flying up in the air. So, and actually, I think you might have...
You're located like across the interstate from the airport, right?
Like the
pretty
highway,
much the off-ramp leaving the airport
right,
is
directly in
the
line.
aerial. So,
correct,
yeah.
yep.
Okay.
So, and actually, I think what you were just saying, so when we first were asking for the 20-foot front setback, we thought that the easement was going to be much more extreme than it is. He drew it in at the 30 feet, the actual platted setback, maybe one slide back. And so we realized that we can adjust our plans, and we actually only are requesting platted setback rather than contextual. We do not need the 20-foot front setback anymore. Which I think is what you guys wanted to grant last time, but you wanted more information to do that.
What is the required setback on lot 27? Remind me again, and I know it's...
I think it's like 42.6 or something. I think it's the dotted line on the...
Yeah, and you're wanting 30?
We're wanting to use the original platted setback of 30.
Okay, so a 12-foot variance, essentially.
Correct. And that will get that back corner out of the drainage ditch, and then we'll adjust the left house on lot 25 to still fit not in the easement of the 30-foot platted setback. Because I believe Mr. Hargis told us last time, even if we get under the 30, we have to go to Planning Commission or something, correct? So we'll work within the constraints of the 30-foot platted setback if possible.
Any questions? Any more questions?
Chair, I'm sorry, may I briefly respond to two of your questions? The easement, the stormwater easement is not actually a recorded easement. It is a prescriptive easement. The contextual setback on lot 27 is going to be 48.25 feet.
And what would that contextual setback be on lot 25 then? Would it be different? Or?
Well, I don't think that it would be different.
Okay.
It looks to be parallel.
Yeah, it would be probably exactly the same.
Here is a photo of what Lot 27 would look like if the contextual setback was enforced. And then on the left-hand side, they've got a site plan for what Lot 25 would look like if they were granted the 30-foot platted setback.
That's showing, that looks like it's showing the contextual at 41.9 feet based on that image, so.
That may be the case, but
Okay.
we calculated it at
It's
48.25.
Okay, 4.25, okay.
Yeah, so if his calc is wrong, then we would actually be farther into that drainage ditch on lot 27.
Our proposed conceptual setback on this survey shows 40.9.
But yeah, he might have got something wrong.
So what we're asking is, we're trying to build houses that fit in with the existing context of the neighborhood. The neighborhood was built in the 60s. These setbacks were established in the 60s. They're single-family, one-story homes. We're trying to fit within the context of that neighborhood. We're trying to build affordable housing, and originally we came in asking for 20 feet. We're asking for 30 feet now.
Yeah, we're just asking to use the platted setback.
So it would be an 18-foot variance you're requesting, as I understand it.
Yes,
Yeah, okay.
if
So
that's
you
what
want 18 feet on lot 27.
If we go by what we're saying the
Yeah, I got
contextual
you.
setback is,
Correct, yep. Then we're just hoping to get up to the platted, the original platted as part of the subdivision.
Any more questions for the applicants? All right, well, thank you guys very much for clarifying all that. We'll close the public hearing and discuss.
We do have hardships
Yeah.
on the survey here.
The biggest thing that I'm having to get over is that were those hardships self-imposed if they literally reinstated these subdivisions in order to create these lots, which allows them to build houses on the lots, which, I mean, it seems very much self-imposed in a lot of ways. Curious to hear others' thoughts on that. I'm also waiting for a horses and courses comment from Ms. Davis down here.
Yeah, so.
You can't use it all the time or it loses
So
its effect.
can
You
you-
gotta pick my spots when I use that.
Okay.
So walk us through that again, if you would, Mr. Newton, the self-imposed part, because it was subdivided into.
Well, yeah, I mean,
28,
it was one lot, and then they had it reinstated the lot lines in order for them to purchase. It was all one lot, and then they essentially made 3 lots out of one lot, so they could build on these other portions of it, which, by creating the lots for that use, and it's almost like, I mean,
They made it. They
Yeah.
made their own problem.
Right.
Can we reopen the public hearing so I can ask them a question?
Okay, sure.
So did you guys have this subdivided, or was it subdivided before you bought it?
No, it was 3 lots originally that the owner purchased all 3 because she wanted a large yard, and then she wanted to sell her 2 side lots, so we did not have to do a subdivide. It was always 3 lots.
Oh, okay. Oh, so, okay.
It was always 3.
So when you guys bought it, it was always 3 lots?
Correct.
You did not subdivide it?
Okay.
No, and she bought it as 3 lots and then combined them and then decided to sell the other 2 lots off. But it's always been 3 lots.
So she bought the 3 lots, combined them, and then?
Well, no, so she bought lot 26, which her house is on, and lot 25, I believe, at the same time, and then bought lot 27, as explained earlier, from NES, I think, in 2010-ish? Is that what was said earlier?
She bought Lot 26 that has the house on it in 1961, very quickly after the whole neighborhood was platted. She bought Lot 25 in 1978, and then they granted the TVA easement on that lot in 1987. This is actually the current property owner. Then she purchased in 2000 Lot 27. That's the one that they purchased from NES, and it always had that stormwater drainage easement on it.
So who holds title to these tracts now? Y'all do?
Yeah, we do on lot 25 and 27, and Ms. Fisher still lives in the house at 26. Correct.
The parcels were combined for tax map purposes. When was that? I know that they were subdivided this year after this application was filed, because at the time that the application was filed, it was all one lot considered to be 629 Claridge. It wasn't until we were processing the BZA application for the first time that it was docketed that we learned it had been divided. So that subdivision of these three plats, it was 3 lots. They were combined by Ms. Fisher, and then they were subdivided this year.
Yes, lot lines were reinstated.
I'm sorry?
After the application was made, they were subdivided?
That's correct. That's the reason why when it first appeared on the BZA docket for the beginning, it was called 629 Claridge, because at that time there was only one mailing address for these 3 lots. And then during the course of processing the application, around that time, the lots were divided again.
Everybody follow?
Well, yeah, so just yeah. I'm not an attorney, so I don't have the brain to follow these kinds of things.
Sometimes you got
So, but Ms. Fisher is the one who re-subdivided the lots, so it wasn't great.
Yes, and there's also, it's in your packet, you'll see where there is a memorandum of sale and purchase agreement that's also executed to an entity called something like Sell My Home. And that was all around, I see my note has, a quit claim deed was recorded February 12th, 2022, which returned these into 3 separate lots.
Okay.
I guess it doesn't bother me as much.
Yeah, fair enough.
Just because lot lines and those things are being reestablished
Yeah.
all over. So this is not unusual.
Right. It helps me to know that they were purchased all at different times, and then they may have been combined for a period of time for some tax map reason, then re-subdivided. So that helps me to understand that a little better too. So.
I also think that,
Do
I
you?
don't know what's going on next to lot 27 to the right of it. Maybe the house is set back 48 foot.
Yeah, that's what I'm seeing on the survey.
I don't know, I think the person who would be harmed the most by pulling the 4 houses closer to the street would be lot 26. I don't know if she had an objection, she would probably tell us.
Yeah, there were no objections in the packet that I recall, so.
Well, lot 26 is Ms. Fisher.
Right, that's
Yeah.
right.
Yeah.
I don't know, it doesn't mean that they do this variance request. However, there are some hardships on the site, both of them.
Yeah, I definitely, well, yeah. I see hardships on lot 25. I mean, I think you should be able to build something on that lot. Are you required to be able to build 2 houses? I don't know about that. That's the question. As far as lot 27, I think they could build a house at the conceptual setback, or contextual, it says conceptual on my survey, I say contextual setback, but you just may not be able to build 2 houses. So.
Right. You might not be able to do that on lot 25 either.
Yeah, that appears to be the case on both lots. You get a single house on there. But
But not 2 houses.
No, I could go both ways.
Well, and also, like, I always appreciate it when people come back and we ask them to do what we asked. And in this case, they gave us way more information, which I do appreciate. And I do understand why you can't run a drone near the airport. Totally get that. But, like, a lot of times people just go to the site and take a picture. Like, you can go on the street, like, whenever I've seen these before, people just go to the site, take a picture, just so that we can get an idea of the landscape. And I realize that the house who's in the middle isn't objecting, but, like, sometimes we have to think about the future. Like, that person isn't going to always live in that house. So I guess my only issue is it just seems like, I think a variance is necessary. Like, I don't have a problem giving a variance, especially on lot 25, but I guess the thing I'm still circulating in my mind is like, do they need this variance? Do I have to give this one? Is there another one that still gets them where they need? And it just sounds like they could do some of what they wanted, they just can't do everything they want without a variance, and I don't think that's enough of a hardship. Like, I don't think the hardship request matches what they're asking me for, so.
Profit.
Huh?
Profit.
Thanks, Tom.
I'm on a roll today.
I'm not quite understanding the easement situation on lot 27.
Well, it's not an easement. It's not a recorded easement. The one on the most recent survey is just where the surveyor drew in for them the approximate drainage ditch. On the first survey, there was running along the boundary line with lot 26. I think there is a recorded easement.
Am I able to make a comment?
Whoever actually closed the public hearing.
Yes. Go ahead and make a comment. Then we'll
Okay,
close it.
so what you see here, north of lot 27, all the stormwater from that street that intersects with Claridge Drive at a 90-degree angle, all that stormwater comes down in a culvert in a reinforced concrete pipe underground, and then it discharges onto lot 27, between lot 27 and lot 26. So it's a massive amount of stormwater. So the reason that we're asking for this is because if you go back to where the LiDAR shows the ditch, there's a ton of water that comes through there. So we're trying to match the existing context of this like 1965 neighborhood with all this water coming down, but we want to make sure that our houses aren't going to be inundated, so we're asking to shift them up. In regard to lot 26, Ms. Fisher's a 93-year-old woman that has indicated that she wants to sell us that lot as well. So in the future, we intend to come before you again to ask for something similar, depending on what you all grant us.
Well, and I understand everything you're saying. I also, just because it is zone R and you can have a duplex on here, it doesn't mean you have to have a duplex on there. You can build a single-family house, and you could do that without a variance. Like the one on the right here on lot 27, you could build that with the contextual setback without a variance and go on your happy way. I know that there's profit that you're trying to make as developers. I get that, but that is not a standard for a hardship there. So I'm having a hard time. So I think there may be something on lot 25 that would be appropriate.
So what would you, and we need to officially close the public hearing, so we'll officially close up. What do you think would be appropriate on 25?
Well, if the contextual is 48.25, I think something in the 35 to 40 foot range would be appropriate there. I don't know if 30 feet is right, but it looks like that just based on what I'm seeing on the well, depends on the type of house they want to build there. But you could build I'm looking at Miss Fisher's ranch house next to it. You could put that on there at the contextual setback, and it would fit.
125.
Yeah, just turn the other way, and they want to kind of get two on there. I don't know. I'm having a hard time with this, honestly. I'm interested in hearing what you guys say.
Got a question. What do you think about that alternate design where they pushed it further back? I'm not seeing it in our packet, but they did show it on screen.
Okay.
We can bring it back up on the screen.
That one, yeah.
Still at 30.
That's
That one's at 30, yeah.
I got one question. Is there, in point of fact, a quitclaim deed? I mean, as much as I love looking at creative documents that Rudy Title has filed for record, David memorandum of purchase and sale agreement, there's no conveyance there.
Yes, Ms. Fisher owns these properties, so if you look at your agenda, Ms. Fisher is the property owner, and
Still the property owner.
that's my understanding.
She's not.
No.
The memorandum thing that you're looking at was an agreement between her and some other purchaser. That's not us. But there are actual real deeds that
All
have
right, so
been.
can we open, we'll open the public hearing up. We need to do that. So you're representing to us, you have a deed for these properties that
Correct.
They've closed.
Correct.
Been to the closing table, got the deeds. Okay.
Correct. Currently on the parcel viewer, it gives us ownership.
All right, thanks. All right, we'll close the public hearing now, so.
Parcel, you're right, I care about a piece of paper that's got an actual transfer of dirt.
You want me to email it to somebody from Register of Deeds right now?
I think this would have
close
to
it.
do with the fact that the application was filed before those deeds were executed, which was on February 12th. That was the quitclaim deeds that returned these parcels into separate parcels. I don't know whether that also conveyed it.
The imagination, don't take it that way, please. I wasn't trying to, I'm just going, this chain of title is all screwed up right about now. The right people.
Yeah, I don't think that that the deeds were submitted. Now, in terms of the affidavit and memorandum of purchase and sale agreement, it was for property located at 629 Claridge Drive regarding lots 25 and 27.
I see they're trying to do something with it, but there's no conveyance to it. It's this damn law degree that I got at some point in time in the past, just causing all sorts of problems. So there's a quitclaim deed or some type of instrument somewhere floating around out there that somebody, either at Rudy Title or wherever, no, I'm not advertising for them, thank you.
Flawless, there's a recorded deed showing Cream City Development LLC recorded March 7th, 2022 for this parcel.
That was after the first time we...
No. Way before.
I mean, I'm on the Register of Deeds website, and there's the, yeah. I mean, it's a recorded warranty deed for both parcels.
So we do have a warranty deed close.
Yes,
Right? Great. Oh, I'm so, thank you.
So, and I'm relying on our architects here, and I think what I'm hearing is that you believe something can be done. You can still build something suitable here without having the variance they're looking for. I'm hearing that's coming up with y'all, I think.
On lot 27, yes, I think you can build a house on that right side of it. Lot 25, I keep forgetting that their setback line, their contextual setback line is up about 8 feet, 8 feet from where it should be, per the testimony of the zoning part. So that one's a little bit tighter. I think there is more of a case for a variance on that lot.
Okay. And I think you said you'd be willing to go 35 to 40 feet.
Yeah, I'd say somewhere in there.
Well, so, okay. I mean, I see the point with certainly with 27 that their plan right now is to do a lot with it with 2 units.
Right.
I do think 25 it's a tighter crunch, so.
Well, and they testified trying to fit into the neighborhood with, similar sized dwellings. I mean, the rest of this neighborhood appears to have, just looking at it on a broad context, appears to have more single-family dwellings on lots rather than duplexes. So that would really fit in more in the context of the neighborhood at that. Now they can build, if they can figure out a way to deal with the setbacks, they can build up to 2 houses, but they don't have to be able to build 2 houses there.
And you're looking at an aerial image?
Sure, I'm looking at an aerial image from Parcel Viewer just to see that.
I guess not in the record.
Yeah, correct, yes, yeah.
I don't know. I think one of us.
We're not public hearings.
Yeah, I was about to say,
That was good.
or it sounds like where you are is you would deny the request as a lot 27, you would give them some variance on 25.
I think that's, generally.
Okay.
What are you thinking?
Well, I'm just thinking, I do think about the future, too. And so then we'll have lot 25 will be closer to the street. Lot 27 will be a little bit further back. Lot 26 may or may not be redeveloped in the future. So we're getting away from the contextual lines.
Yeah,
That's
true.
That was my thought.
True. And it does look like the house that Ms. Fisher lives in is pushing up the average of the setbacks in general, being 55 feet away, so 54.9 feet away.
Like the neighboring property might be 48.
Yeah, 48.9 and 41, and the one next to that, so.
I mean, if 40 might be.
Okay, so it
Next to
sounds
lot
like we have
27.
two people who are okay with 40 on,
But that 40's on 25? That 40 doesn't apply to 27?
We're not touching 27, is that what I'm hearing?
Well, my personal thought was granted on both 25 and 27, so there would be consistency.
There would be consistency. I can support that. You want to make a motion?
I'm sorry to interrupt. In terms of
oh,
consistency.
sir, you can't. We've closed public hearing, so we're discussing, we're going to vote.
Okay, so
So
I will.
make a motion.
Yes, I will move to allow a variance request to the street setback to be 40 feet due to the easement on lot 25 and the existing stormwater drainage ditch.
So 40 feet on both. Okay, is there a second? Second. Okay, we have a motion and a second. All in favor, raise your hand, say aye. Aye. All opposed? So that passes 5-1. Thank you. Okay, so we'll before we call the next case, we can take about a 10-minute break.
We're calling the meeting back to order.
Spitting out dollar bills at me to the tune of $4, so, all right, well, I made an effort. Okay, next case.
That was nice of you.
Well,
Okay, yes. So the next case is 2022-31. This is a request for a variance from the street setback for property located at 2402 Valley Brook Road, which is in the RS 40 zoning district. That district establishes a 120-foot street setback requirement. On the presentation decks, we have the zoning map of this area, an aerial photo of this property and the abutting lots. Here's the condition of the lot as it exists. It's currently vacant property. And here's the survey that was submitted. The applicant was requesting an 80-foot street setback variance. Is there anyone here in opposition to this matter? Okay, seeing opposition, the applicant may come forward. Gentleman's name is?
Fair Graham.
Mr. Graham? Chairman, I don't believe the applicant is present.
okay, so why don't we pass that one case and see if he shows up? You all want to do that, or, okay. Yeah, we'll.
May I ask the neighbors if they have any information about,
Yes,
we've received a lot of communications, and I'm
Okay.
unclear whether this matter is going
Yeah, we have
forward. I
a
wish we
volunteer.
had.
Do you have any info about where the applicant is?
My name is Frank Berryman. I live at
Can you
3411.
speak up a little bit, sir? And if you'll use the mic, we'll be able to hear you.
My name is Frank Berryman. I live at 3411 Valley Brook Road. The developer or builder was upset at our opposition, and the day after the meeting, he sent around an email telling us that he was going to flip the lot to Richland builders who were going to come in and build a big ugly house.
Okay. So he indicated to you that other neighbors, he was not going forward with this application. He had other plans. Is that fair to say?
He told us he was going to flip the house to another builder, and he was going to come in, new builder was going to come in and build a big ugly house, and we'd regret our opposition.
Okay. All right, thank you, sir.
Thank you, Mr. Chairman. Yes, my understanding from neighbors is that they had anticipated that the applicant would withdraw this request, but we've not received any communication from the applicant.
Okay, well, the neighbors have been here twice, and I don't see any reason to pass it based on those circumstances.
Make a
because
motion, we deny the request.
it sounds like he's just not withdrawing
general
maybe
session.
intentionally.
Yeah.
So we'll just.
Make a motion, we deny it.
Okay,
I second.
all right. All in favor of denial, raise your hand and say aye. Aye, okay. That application is denied, so.
It was a great in the century.
Okay, thank you. So you all are free to go if you would like to. Thank you for being here today.
Thanks, folks.
But for everyone to get settled.
Chairman, while the room gets set, I have, because of the election cycle, the council moved their hearing for our new board member, and I've actually have to testify in front of a committee at council here at 4 o'clock. So where we get, I'd like to at some point if we could pull the item A forward.
Okay.
If at the very least, just to get my testimony on the record and I can depart.
Thank
Okay,
you, yes.
Can we go ahead and pull that one
Yes, sir,
forward?
Chairman. That one would be case number 2022-50. I'll pull those slides up.
Okay.
Thank you. This is an item A appeal of the zoning administrator's interpretation, a Metropolitan Zoning Code, Section 17-12030C3, as applied to property located at 923 Sutton Hill Road, which is located in the RS10 zoning district. On our slides, I'm sorry. I thought I had it pulled up to the right slide.
No pollen in the trees.
That's true. That's probably in the 2020 areas.
It's better. So this is the zoning map of this parcel, RS10 zoning district. Here's the aerial map of this neighborhood. Here we have some photos of the current condition of the property, which is the one in the top there. It's vacant construction site, and then the other two photos are the immediate neighboring parcels. Here we have the site plan submitted by the applicant. Is there opposition? Well, I should say, is there anyone here in support of the zoning administrator? Okay. Okay, are there other parties here?
Too bad, Joey.
I actually did have a hand.
Oh, you did have a
Yes.
thing. Okay.
Are there parties here who are wishing to present your application today, the appellants? Okay, so then the zoning administrator will have 10 minutes. We'll hear then from, help me.
Actually, if the gentleman wishes to join in the support, I'll go first. I'll turn over to him. If he wishes to speak, if he doesn't, that's
Okay,
fine.
thank you. Then, so we'll go ahead and hear from our current zoning administrator, Joey Hargis, and then after that, our previous zoning administrator, John Michael, is also present to be heard by the board. Thank you.
All right, members of the board, thank you. This appeal comes from the neighbors who have requested that this board enforce a setback that is greater than what the zoning code requires by law. So, and let me say on the front end, I am sympathetic to the neighbors and the situation going out here. I do understand. Elizabeth, can you pull up the street line that was there? Yeah, that one's perfect. These homes at the time they were constructed chose to all go around 80 feet plus, roughly. And so they did create an established development pattern. And so the nature of this request comes to you because an appellant is, and it's the subject lot that you see there in the middle, is removing that structure and building a new structure. And the zoning code, unfortunately, only requires a maximum setback of 60 feet. So to the neighbors that are present here, I have no choice. Whether I agree with you or not, I'm stuck at a 60-foot maximum setback. So understand that. And I beseech the board, too, that to uphold me and uphold the code as written. The councilman did come, and he and I have not talked specifically about this situation, but I have talked to other council members before about amending this code section to require it, to take out the triple setback maximum and just say, hey, whatever the context is what we're going with. And I'm fine with that. I don't have any problem. My only issue with, in this case, if this board grants this appeal, you are creating chaos in my office because I have to enforce the code as written, but then I have an appeal in this situation where I'm applying a different setback than what the law says. But let me read to you the code section here since I've got 10 minutes. I don't typically take that, but I may take just about quite a sizable chunk of it. The zoning code in 1712-030 C3 states that in residential areas with established development pattern, the minimum street setbacks for R and RS zone districts shall be the average up to a maximum of 3 times the standard table provided in table 1712-030A of the 4 nearest single-family or 2-family houses on the same block face that are oriented to the same street and that follow the established development pattern. The next 2 paragraphs give me situations in which there are less than 4 houses involved. I won't read those because they're really not germane to this situation. And then the final paragraph talks about when there are no other houses, what do I do? But in this case, I am stuck by ordinance with this. Now, the very person who can change that is Councilmember that spoke before and his colleagues in our Metro Council are welcome to change the law at any time. From the standpoint of I'm tasked, and John Michael, who's here to speak on behalf, we're enforcing the code as it's written. We're sort of musicians in the symphony. We don't always get to pick the music, but we play the song as it's written. And I do sympathize with the neighbors in this case, but my hands are tied. It's 60 feet is what's required. The section I read from talks about the table in 1712 in 030A, and again, for the purposes of record, the zoning code is a part of this ordinance. But I'll read to you this particular, the minimum street setbacks in the table are set forth based on how the property is zoned. And this particular parcel is zoned RS10. And the RS10 minimum setback is either 20 feet or 40 feet, depending upon the type of street. And so in this case, we look to the major collector street plan adopted by the Planning Commission and as part of its general plan, and then adopted by reference through the council that states that triple the table. This particular street, Sutton Hill Road, is a minor local street. So when I look to the table in the chart itself, and this was the way we used to do setbacks, we just looked at this chart and said, okay, here's your, depending on the street, it's either 20 or it's 40. And these were minimums at that time. When I look at RS10, the minimum street setback is 20 feet. The only alternative to that 20-foot minimum is if we had a legally non-conforming 2-family dwelling, but again, that's not in front of you. So for me, I look at that chart, it's 20 feet. I'm by ordinance told in this section I've just read that I can enforce but 60 feet or triple that table. I think you've got another case potentially before you today on setbacks with some lots that are in the context were greater than that triple the table. And I will use those distances if they're not greater to such a degree as to just completely blow the average out, So, if I've got a house sitting 400 feet back, I'm probably tossing that one out because it will completely skew the average. But the zoning code gives me the authority to throw out outliers. As you see this development pattern, it's a fairly straight line. And I am sympathetic to the disruption that a 60-foot setback might cause here. But I'm tasked with enforcing the code. Now, I do ask this board to uphold me and how we interpret it. The outcome of not interpreting it is chaos. It really is. Not just for this lot, but for all the other lots we deal with, 50-something thousand permits in a calendar year, and how we enforce street setbacks now or do that. It's really the gist of what I have. Mr. John Michael, do you have anything you'd like to come forward and add? appreciate the support.
Thank you,
I'll give
Mr.
the balance of my
Hargis.
time to Mr. Michael.
Well, we're going a little out of order here, I think. Shouldn't we give the applicant a chance to, I think we need to go with the applicant and then Mr. Michael.
No worries.
Touche.
All right. I'll reserve the balance of our time for Mr. Michael's testimony.
Thank you. Then you all applicants will have 10 minutes together, and if you would please state your name and address when you get started.
My name is Jeremy Barlow. I'm at 1003 Sutton Hill, and I will try to fight this uphill battle, which we are very aware of, quickly because I have some of my other neighbors here who also would like to say a few words. You know, first off, I can't imagine being in codes right now with the development in the city. That must be a brutal job. We understand that this permit was issued legally by the code. But we hope that this board, in their role as an appeal board for variances when codes are legally denied, can look at this and say, in this situation, this setback code does not fit for the neighborhood. And basically it is, to give you some brief history, same builder, same owner, did next door to me 4 years ago, tried to go 60 feet. I appealed it. They came and knocked on my door. We negotiated a settlement that worked. They pushed their house back. As soon as we saw the stakes for this property on March 5th, I think it was, I sent some emails regarding our back and forth. We contacted them and say, hey, same guy, same neighborhood, we're going to hit you up again to try to move your house back because it completely destroys the contextual line of the homes that we're all in. If we were in a neighborhood that was totally about to be renovated, I think we'd have less of an argument. But the reality is this house is the last house in a 7-house row that has already been rebuilt in the last few years or renovated and has kept the contextual line. So we will have one house on this whole side of the street. I have it not officially to you on the 3rd, but kind of highlighted all the renovations that have happened in our neighborhood in the last 5 to 10 years of houses that aren't going to get torn down and rebuilt, and this house will stick out in front of all of them. One of our neighbors took a great view of the dumpster today, of the work they've done in the last week, which it's no longer an empty lot. There's now foundation and walls and poured slabs. As of this morning, they were pouring concrete. But this dumpster kind of shows how far in front the house will stand compared to the line of houses. And so, you know, our reasoning for overturning is definitely not to cause chaos in zoning. We certainly understand it. It was good to hear Councilman Pulley talk about issuing some legislation to change this, understanding that it does not work in some situations. And you know, I think that's kind of my words as it is. You know, it doesn't fit. We've already renovated our street. It's going to stick out like a sore thumb. It's going to completely destroy the contextual line, which has been an overarching kind of theme I've heard in every discussion today. And then I'll yield time to some of my other neighbors.
Mr. Chairman.
But I thank you for listening to me.
Yeah, can you, sir, could you, Mr. Barlow, could you, can you circulate those pictures with you?
Yeah.
They make them part of the record, but I'd kind of like to look at them if it's possible.
And if I can ask you a question, which won't go against your time.
Yeah.
So did I hear you say that the properties next door to this one have also been built in the
They have already been flipped or completely rebuilt like my house was, or and I had actually lived in that property for 12 years before we tried to renovate, had to tear it down and rebuild it, or renovated from the existing structure and are all on that contextual line. And part of the map I showed you, everything highlighted are properties in this area that have already been redone. So this would be an outlier of a house. It wouldn't be the beginning of a neighborhood flipping and everything moving up, which I did some research on this amendment that Councilman Holloway put in, and part of the purpose was to establish contextual lines in neighborhoods. So it's actually, in this case, upholding it is doing the exact opposite of its purpose, which is kind of one of our arguments.
So for the purposes of the record, just in case, the items that you have marked in yellow.
Yes.
Are the newly developed or built?
Yes, in the last, I mean, I've been in that neighborhood since 1997, and so first time Marengo and then on Sutton Hill, but all of those are recent. You know, I didn't go look at the exact years, but I know from being in the neighborhood that that house flipped its inside. This house was torn down and rebuilt. Some of you can tell, Mackenzie, the developer today, has done 7 houses in our neighborhood, and up until this one, has done a great job. They build a great house. They keep it in line. They're doing good things for the neighborhood. But I don't understand why they need to push this house forward 20 feet when the lot size is big enough for them to maximize the same amount of profit by just pushing the house back and still have a backyard. So I'll yield my time to some of my neighbors to talk.
Are these, or can we keep these and make
Yeah,
this part of the record?
keep it,
Okay.
for sure.
Part of the
All right,
record.
Thank you.
I'm going to move that we do include them in the record.
Yeah, no, they'll be made part of the record.
Thank you,
That's-
sir.
Good afternoon. My name is Colin Brown. I live at 1005 Sutton Hill. I'm Jeremy's next door neighbor. I'm 3 houses down from the house in question that we're here to talk about today. And I'll be very brief because I think Jeremy did a good job of explaining our situation. Each of these lots are 1/3 of an acre. You can build very large houses on these lots. I live in a McKinsey house. I'm sadly part of the problem. I bought a McKinsey house, and that was the house that Jeremy mentioned, where previously McKinsey was willing to come up with a reasonable compromise on a line that would not affect the contextual look of the neighborhood. Easily, McKinsey can build a 5,500 square foot house without being 20 feet forward from all the other surrounding houses. You are not in any way harming McKinsey economically if you find in our favor and require that this setback remain with the context of the surrounding houses. It's not going to cause McKinsey any harm at all, but it is going to harm our neighborhood. I am also the newest neighbor, I think, on the street, and one of the primary reasons we chose to live on this street is because of this context. I mean, it's very aesthetically beautiful, and once McKinsey does this here, all the other developers are going to come in, and it's going to completely destroy the contextual look of the street. Right now, our house, our whole neighborhood, there's kind of 3 streets in a row, and it's like a war zone in terms of construction there, like it is everywhere in Nashville, right? But somehow, all the developers this far have been respectful and have been willing to maintain the contextual look of the street. And while I understand the code is the code, I think this board has some flexibility here, particularly when it won't harm the developer, the person who came in and bought the property. They're going to be able to make their millions. The prices of homes on this street have doubled in the past year, practically. So I would just urge this board to thoughtfully consider requiring McKinsey to abide by the contextual line. Both of the houses on each side of the house in question are at the 80 feet. And look, McKinsey will be able to build a 5,500 square foot house at that line. They'll make their millions, and it's a win-win for everybody. Thank you.
Thank you.
Hi, I'm Anna Teeples, and I live around the corner from Jeremy and the house in question. I've been in the neighborhood for a while, and I actually design houses. So I'm the person who designed the house that is Jeremy's house. And when I look all the time at surveys that tell me what the setbacks are, and the setbacks are constantly referring to the contextual setbacks of other houses. So I was involved 4 years ago when we addressed the issue of the house next door, and it was news to us. It was news to me because I'm constantly looking up what the setbacks are as I'm designing houses here in Nashville. So I was unaware of this other clause because I always reference the contextual setback. It's not referred to on surveys about the minimum standard that setbacks can be set, and I think that is kind of a given that even at the survey companies, they're using the contextual setback. So it's been a new awakening to me that there's this lower level that we can all develop to that I'm not sure I appreciate. I appreciate the neighborhood that I have been living in. And one of the things that's really appealing about our neighborhood that was established post-World War II and the early 40s is that this has been a generational neighborhood. We have people who are living here that are 3rd generation from there. And we're not a backyard neighborhood, we're a front yard neighborhood. Our kids play in the front yard. When you start to move these houses up, they don't have that anymore. We have block parties together. Our kids do neighborhood events together. We trick or treat together. And so all of a sudden, we've become the tear down neighborhood. And I don't like that. I like the fact that we're a small bungalow-style home that is slowly getting lost. And that's because we're losing this battle of the setbacks. So I'd like to ask you all to preserve the contextual setback, because I think it's respectful and it's really kept the charm of our neighborhood that really endures us. So thank you.
How much time do we have remaining for?
1 minute remaining if anyone else would like to be heard.
If you want to reserve that for rebuttal, or you can.
I think we've said enough. I think we made it clear.
Okay, well, if you decide after.
Well, we can reserve that.
Yeah, you still have a minute and a half left, or a minute, whatever it is, if you want to talk on rebuttal. So.
I'll save it for that then. Thank you very much.
Okay, and then Mr. Michael, is Mr. Michael still present? Oh, hi.
Good afternoon, board members. My name is John Michael from the Thompson Burton Law Firm here in Nashville at 1801 West End Avenue. I represent the development group that's building this property at 923 Sutton Hill. As has been correctly identified, the house utilizes the setback that is created by the law that has been discussed here today. Mr. Hargis laid out the very straightforward legal provisions. If any of you board members on an individual basis have questions about what the law allows here, I'm happy to try to address them as well. I think staff is best equipped to do so and has capably done so. But as you know, an item A case turns on a fundamental question, and solely this fundamental question: did the zoning administrator get it wrong? Was the permit issued in error? Was there an incorrect application of the Metro zoning code? So as you consider your vote, you'll be considering whether or not staff got it wrong. Respectfully, I contend that staff did not get it wrong. This is a relatively straightforward ordinance in most instances, insofar as the complicated algebra of determining your average based upon the 4 nearest developed lots in the context. As far as that can be straightforward, it sort of is. But the caveat with regard to a max distance triple the setback from the original charts is the part that governs here. So, although there are those who say that it doesn't work aesthetically, and I have no qualms with that, these folks know better than I, because I don't live on this street. I do not wish to pretend that somehow my opinion with regard to the aesthetics should be the governing one. Similarly, I will contend that no opinion with regard to aesthetics has a place in this conversation. The only question legally presented to the board by the appellant's case on the item A is, did staff get it wrong? You've got a very clear, objective, literally black and white in the zoning code answer to that question, and it is no. And therefore, we'll ask that you uphold the staff's determination on this case and deny the item A appeal. Although there are those who have said that for the appellants to have, or rather for the builders to have followed the law in this case is disrespectful. I say that it is not. We have heard that for the builders to have followed the law in this case is greedy. I would say that it is not. For them to have followed the law was unethical, and maybe that wasn't in your documents, but it was in correspondence I received. I contend that it is not. And that for the developers to have followed the law in this case will ruin trick-or-treating. I will contend that it will not, although we have until October to find out. Again, we ask that you uphold the zoning staff's correct determination of the law in this matter and deny the item A appeal. Thank you for your time. Naturally, I'm happy to answer any questions board members may have.
I actually have a question. So, Mr. Michael, I understand your argument to be that essentially this is a black and white issue, that the code staff follow the law, and this is the fair application of the law. My only question is, when I read through this notebook that I got several years ago with the code in it, wasn't one of the predominant reasons for creating this though was to preserve established development patterns? I understand your argument, but
yes,
is there an argument in this?
Your question.
Yeah, go ahead. So
No,
I
you're
think
on it.
I understand what you're saying, but I also think when I read through this, one of the things that the code seeks to preserve is established development patterns. And right now, when I look at this, yeah, the law tells me I can do it, but it doesn't seem like it preserves it. So I guess that's my question, and if you have a response to that.
So here's the response. Yes, when Councilman Holloman conceived the idea as the council member for primarily the Sylvan Park neighborhood, and I am not digging into true legislative history from floor debates here, just conversations that I've had with him in the past, many years ago when I was still at Metro Legal and then at Metro Codes. Councilman Holloman talked about in various parts of Sylvan Park, there would be reasonably well-established contextual setbacks, a term that we kind of invented for this ordinance, but that works. And occasionally somebody would come by, build to code, and it would create a wonky set of lines. The flip side of that same analysis we saw in parts of District 24, closer over to West End, maybe 5 or 6 or 7 years ago, where we had an old farmhouse near Bowling that was 150, maybe even 200 feet off the street, but as a farm had maybe 60, 70, 100 years ago been sold, carved up into a subdivision. We had one house that was 200 feet off the street and a bunch of others that were maybe 50 feet off the street. Zoning guidelines come in 64, are revised in 74, updated again in 98, and those setback lines that are in place allow people to build. Then contextual says, oh, you want to tear down the small house here and build a new one. Your setback is going to be set by this contextual street setback ordinance at 1712-030, whichever letter, I think it's letter C. In so doing, you're going to measure, okay, this is 50 feet off, that's 50 feet off, this is 45 feet off the street, and that's 205 feet off. Go do the algebra. And we argued and argued and argued that 200 needed to be thrown out. There was a brief period of time where the BZA disagreed with that interpretation. Court chimed in and said, no, that should be thrown out. That's consistent with the ordinance. So here's where I'm going toward yes. Yes, context was the policy rationale for that ordinance. However, when you have a street like this one, where the houses were built 80 feet back, which was not the requirement of the law, but a choice by the builders, it's then tough to come back later and say, well, yeah, the law allows you to build to 60 or 40 or 20 or 75 or whatever it may be. But because everybody else chose to forego that opportunity, we're going to make you do the same. And so there's a tough public policy rationale then for the private property owner to say, you have these private property rights, but we're not going to let you exercise them because other people chose to forego them many years ago. And I'm not talking about our neighbors here today. Very few of these folks built the houses they live in or built the original houses on those properties in the 60s, 70s, or 80s when a lot of that was really growing fast in the Green Hills area. So to your question, was it part of the point to create some context? Yes. Was there a safeguard put in place in that same piece of legislation to make sure that people who had voluntarily pushed back didn't necessarily overly restrict what would otherwise be allowed for future builders? Yes. And is this a manifestation of that safeguard? Yes. They got the law right in application. I would contend this is one of the reasons that they have that safeguard in place from the original legislation that Councilmember Holloman brought forth during his second term. And when Bill Herbert was zoning administrator, when his successor was zoning administrator, with Mr. Hargis as zoning administrator, everyone's read it and applied it the same way. Again, I get that people don't like it aesthetically. I have no opinion on that. But this is a matter of balls and strikes. Discussions of aesthetics are potentially valuable in community character manual discussions at the Planning Commission. Discussions of aesthetics are potentially valuable in discussions of proposed text amendments at the Metro Council. At BZA, with the question of did the staff get the law right or wrong, it's not even on the menu. So while I'm happy to take other questions, I hope that's a, if overly thorough, at least sufficient answer to your question.
Any further questions for Mr. Michael?
Why did the builder decide to build 60 feet at the 60-foot setback? Why not at
I didn't ask him what the preference was. I just asked if it was legal. It could have been aesthetics, Ms. Carpenter. Everyone has a different taste.
I wouldn't call it aesthetics. I'd call it something else. Okay.
Get a minute.
Be happy to answer any other questions the board may have.
Well, Jeremy, again, I certainly don't claim to have the legal skills in arguing nor the codes expertise that Mr. Michael has. But the examples that he used regarding the reason for the codes were exactly our point. They're in a different neighborhood with a different situation. And Battlefield Estates, which is one of the oldest neighborhoods in Nashville, our contextual line has been set since 1935, which I think someone had found out is when the subdivision started being built. So we're not saying the administrator got it wrong, but we're saying that in this situation, it doesn't fit. And I have seen the few times I've looked through the code that the administrator has an ability to say, no, yes, this is the code, but no, this doesn't work.
You have 40 seconds remaining.
Oh, shoot. And say, no, it doesn't work. So I think the purpose of this board is an ability for neighbors to come up, as it is for developers to come up, and argue a point in which goes against what was issued in zoning. Not right or wrong, just simply it doesn't work in this section. Thank you so much for your time.
Thank you, Mr. Barlow. Okay, we'll close the.
Pepper.
You have a question?
I've just got a question.
Yeah, Mr. Barlow, Mr. Lawless he has got a question for you.
If you would, please.
Just
Okay.
hanging out with my neighbors.
You're on a roll. You might as well just.
All right, I'll keep it.
All right. So, just to clarify, all the houses down the street, they've been that way for probably back when you were a young man and had hair. Right?
Yes, I lost hair early on, so unfortunately, it's been a while.
That way for quite.
They have been in those spots for as long as that neighborhood has been there.
Okay, and this particular builder that you have some experience with.
Correct. Positive experience, I might add.
It clearly saw that. Clearly knew what was going on there.
Correct.
Decided to go off on his own in a new way, notwithstanding. Okay. Thank you.
Yes.
Thank you.
Anything else?
All right, we'll close the public hearing. Mr. Hargis, do you have something?
I would, just for clarification of the appellant statement, I don't have the ability to not enforce the law. And I'll remind this board that this type of appeal says the appellants are alleging that the zoning administrator, it alleged in writing that I acted arbitrarily or in error. And it by his own statement, he just said, we're not saying the zoning administrator got it wrong. I didn't make an error. But for me to enforce the setback that the neighbors wish me to would cause me to act arbitrarily. So I just put that on the record.
Okay, we'll close the public hearing and.
Can I ask Mr. Hargis a question?
Sure.
So you just said that if you do what the neighbors want you to do, that would mean that you're acting arbitrarily.
Yes, ma'am.
But could an argument be made that by by putting the house back where everybody else is, you're not acting arbitrarily because you're basically keeping that house in line with every other house on that street and maintaining the contextual line? I'm asking. That was just.
I would only agree with you if, but for I have a specific code requirement that says the maximum shall be 3 times the table.
Okay.
If I did not have that sentence there, oh, absolutely. I actually agree with the arguments from the standpoint of this 60-foot setback would violate the context of this block face, but for the code as written, and which is all I have to enforce, it doesn't matter whether I agree or disagree with the applicant. Their appeal is, did the zoning administrator err? I clearly didn't err. The code says what it says. They're asking this board to act as a legislative body to change the law, and that's not this board's power.
Ask a question just for future purposes on the contextual line. You know, if this one goes through, if we fail our appeal today and it goes through and then Mr. Pulley changes the legislation, or we go off and, as we've been discussing recently, enact a contextual setback.
Overlay,
sorry. Is that, we're going to have one house sticking out in front of all the other houses?
Yes, sir, you would.
So isn't the point to try to avoid that within neighborhood developments and construction and codes?
I don't disagree with you.
Right. So
I wouldn't even argue your case. I guess the point I'm saying is your fix is legislative.
We understand each other.
Yep. I even agree with you.
Right.
I'll say it on the record. I agree that the 60-foot would mess with the context, but the code says exactly what it says.
Right.
And your
so we
fix
could
is legislative.
theoretically pass this appeal so we could push that house back, and then as a neighborhood, we can fix this problem for the future or work with Mr. Pulley legislatively.
I would get, I'm being speculative, but the outcome of this case could be adjudicated by both Mr. Michael or myself, or you guys.
Probably better address to your council person.
Yeah, I would talk to your council member.
Okay,
Thank you, sir.
of course. Thank you guys for listening.
Okay, we'll close the public hearing. Well, I don't doubt that if Mr. Harris had the authority to deny this application, he would do it. I don't doubt that a second. I just look at it and I don't know, it's disappointing that it's such a disruption of the neighborhood, but we aren't a legislative body. And if I thought, and somebody, if somebody finds it, I'm all on board. I have sit here and thought if I could find the thinnest reed to support finding that Mr. Harris erred, then I'm on board. I can't find it. Maybe I've missed it, so I'm all ears on that.
The function of the board is to either enforce the codes or to look, in this instance, at the equities and justice. And I'm having a hard time with a builder who knew exactly what was going on in the neighborhood. The unanimity of opposition, and Joey may be right, but sometimes what may have been right under the code is not what's right under the situation. This is part of the arguments that are going on today. And as much as I understand and I'm probably going to get outvoted, I just cannot destroy, in my mind, all the people there for one person who knowingly knows what the neighborhood is to go in, and it's because of me I'm going to make everything change when you've got all these people out here. And no, I'm not running for office, so don't look at me like that. I promise you never to do that. Joey may be right on the law, but sometimes the law's wrong. And I guess that's where I'm going to be, and I just can't do it this time. Normally it would have been a slam dunk. This time I just can't, and I have to apologize to my fellow members. I just can't go there.
So Member Lawless, my question is, what's the resolution? What would you propose the resolution is in this case? Like, permits been granted, construction's already started. Are you proposing,
Oh, we have several times stopped someone from doing something when they've already started construction. And they've continued to do the construction knowing that this was coming up. How long ago was the notice, Joey, if you don't mind me asking you? And you may not know.
Notice for this appeal, it's at least 28 days. Well, there's not a notice on issuance of this hearing, at least 28 days out.
So, it's been a month. So,
I apologize, 21 days minimum.
Okay. Excuse me, 21 days. About the same time as you run a foreclosure notice, right? So, but they knew, from previous experience, this builder knew from previous experience there was going to be pushback. They knew that every other house had been done that way. They'd had discussions another time when they were building on one, that they came up to some agreement, some relationship. They've decided now to keep going forward. I understand, and I don't consider it a greed factor or anything like that. I'm all for development and what have you. But sometimes a neighborhood is a neighborhood. We all want to be in a nice neighborhood at some point in time or someplace that we're comfortable. And there's a unique concept called equity. doesn't necessarily have to. Circuit courts may follow the law. Courts of equity will frame something to correct a wrong or an injustice. And in this instance, as much as, and I'm a property right type of person, I just can't do it this one time. And can they stop? Yeah, they can stop. They can move the house back. They can readjust it.
So, Mr. Lawless, I'm trying to, because I want to get there.
I know. I said I may not.
I mean, the law, as you mentioned, the law is very clear. I mean, now whether common sense says the law is right is a different matter. And clearly, the law is wrong here. I mean, that's my personal opinion. But is there an opportunity? Do you believe that our board has that opportunity to say the law is wrong here?
And I do. And I'm just going to put it this way. There was law at one point in time that said I couldn't go to school with Joe or with Ashanti. That was wrong. And until somebody stood up and said no, it couldn't be changed. And it can't be changed. And once it's done, it's done. Once the harm is out there, you can't fix it or frame it. And now I'm pulling the emotional strings on this, and that's just not my style. Hell, I'm a commercial litigator. I'm not this is uncomfortable territory for me. I don't normally go there. But
If I may.
Yes, please.
I think as a board, we're allowed to see more of the gray, and, sometimes the law is written a certain way, and maybe this is, I guess it's not in the bulk regulations, but it's linked to the bulk regulations, and we're allowed to look at a property and see how we need to preserve and protect the surrounding properties. I'm reading from somewhere. It says protect surrounding properties and better carry out the general intent of this title. So if we decide that, we disapprove this this request, then we're not protecting the properties. And so, and I also just think about prior cases. So we've had so many of these contextual setback cases, and we're always, as a board, most of the time, I think, maybe we don't all agree, but I think the way typically the cases have run is that we do our best to get a contextual setback line. And that's something our board has done, I'm pretty sure. I can say that with accuracy. On many, many, many occasions, that's what we've strived for. So if we decide a different way today, then we're deciding differently than we have in the past. I know that.
I'm looking at it.
Yeah. So I would say that our decision today would, if we decide to go with the zoning administrator, we would be contradicting maybe some other decisions we've made in the past and not protecting the surrounding properties.
The equities.
Yes, we say it all. We all say it different. You're an attorney. I'm architect. So.
No, you said it very well.
Mr. Cole, Ms. Davis, anybody else want to weigh in?
I did love your question, by the way.
I think my question sort of gave what I was thinking. It's hard because I think any of us in this room, if we were on that street, I think we would all feel the same way those neighbors do. But Mr. Hargis and Mr. Michael also pointed out that, that this is just a clean application of the law, which is what, on these type of appeals, we typically prefer. So I'm sort of stuck. I will say that our members' comments have sort of kind of pulled at me, but I did go to the first page of Chapter 17, and under the title and purpose, it does talk about protecting the value and integrity of neighboring properties, enhance the general character and appearance of the community, reinforce the central business district. Like, these are the purposes of this code. And so it seems sort of like antithetical to say that's what the purpose of this is. We have spent a lot of time in prior cases saying we got to maintain that contextual line. And now in this one, it's like, well, no, you can't maintain the line because the law says the requirement is this. So I think that's sort of reconciling what the requirement is and then reconciling what the codified purpose of the law is sort of where I am.
Because we're allowed to look at the intent of the law. And the intent was not to have, was to have a contextual street setback. That was the intent.
Yeah, but that intent also included outliers, right? So Mr. Michael brought up the example of you have a street where all of the properties are at a 50-foot setback. You happen to have one that throws off the average that's 200 feet back. So they come up with this general methodology in order to account for the outliers, right? With a broad brush,
Yes,
right?
but keep going, but I'm going to have a...
No, just with a broad brush. So I think that with that clean application of the law, it's to catch all of these exceptions that don't necessarily fit nice and neat within the interpretation. So that, that's where, that's where I'm stuck right now.
Yeah, and that's why we've had so many cases in the past, contextual street setbacks, where that underlier has been there, and they've come to us and they've appealed, and most times, as far as I can remember in my 7+ years, we have negotiated a different setback that would bring the setback, the contextual
You two
street
usually
setback.
figure out how to get us done.
Maybe we did that today too. I don't know, but we this board is allowed to look at that underlier and decide. We look at the gray of it, and we can throw out that one, and we can bring the homes to be contextual. That's something our board's done a lot.
Well, we've always,
on that same side of the coin, just in my experience on being on the board, usually the case is trying to figure out how to push the building forward, right? So for some reason there's a, extreme setback, and they're trying to figure out how can they move the building forward. This is the opposite end of that coin, right? So we're always ruling or trying to figure out some way how to push that building forward. I've never seen us, look at that opposite end and say, well, how can we push it back, right?
But that's different though, because listen, John Michael is way smarter than I am, so don't ever think I don't agree with that. Example is talking about a 200-foot setback and everybody else is 50 and having to deal with that 200 setback. Every house on this block is 80 feet. I don't have an outlier. I have everything being the same. This is the outlier. You're asking me to approve the outlier. I'm just saying, I understand the argument. I understand the argument, but and I understand, like I said, Mr. Hargis and Mr. Michael are way smarter than me. But when I look at this, it's like there's not a 200-foot setback here. Everybody's 80. You're asking me to approve 60.
and to Ms. Carpenter, we do always kind of have a judgment to rule on that contextual setback, but the law is pretty clear that we have a rule up to three times the.
I agree. I mean, you guys are making great points.
I think we all think this is wrong. I'm going to speak for my fellow board members. We all think this is wrong. I just don't know. I mean, I'm sure it'll get litigated somewhere else if we rule a certain way on it. But and these attorneys will make more money.
No, John Michael.
John Michael. Yeah, exactly. Yeah. I can say that's not an attorney, but. I mean, the common sense of it is, yes, it should be back in line with the other houses. I just don't know. I'm trying a hard time, as not an attorney, how we have any kind of opportunity to do that. I'm not sure how I'm going to vote here, honestly.
I think we do. I think. Okay. Yeah. I mean, I've said it. I won't repeat it, but I think we do. We're able. And when I started, a different zoning administrator told me that we could see the gray. And so I took that to heart all these years. We can see the gray. And here is gray to me.
Okay, somebody want to put up a motion?
I am a black and white type person on this, and I want to be in the gray. I'm going to the equities for a change, and I don't normally do that.
Well,
I'm going to make a motion that we overturn the zoning administrator.
Okay.
In this instance, he got it wrong.
Is there a
which is
second?
also a first for me for a while since Joey's been there.
I'll second, and then we can discuss more.
Yeah, we can discuss. And I have to vote against it. I wish there was some way I could find. I think it's a bad law, and I don't feel like we have the equitable power to change a bad law. Even if we did, equity has to follow the law, and I just think I just see no wiggle room. I wish I did, neighbors. I think it's a bad result for you from a bad law, but I have to vote against it. So.
And since I argued so passionately for it, I actually kind of agree with Mr. Our chairman, because even though I think this sucks, and I did just say that, I don't think I have the power.
I concur with that.
I don't think I have the.
Did you get bleeped by the network?
No, I also don't know, I'm not a legislature. I'm in an appointed position. And so because of that respect out of that appointed position and the fact that I don't make the law, I have to follow what the law says, and that's kind of our job as well. And so even though I passionately argued against you, Mr. Cole, I do feel uncomfortable. Just to show you how conflicted I am, I feel conflicted. I don't like that I agree with the chairman, but I think logically he's right, and so I'm inclined to vote with him. So I just want that to be clear, even though I understand the motion.
I've never seen us so conflicted on a case. So,
I don't know. I mean, what's the point of having the BZA if we had to follow the strict application of the law? Why bother having the BZA? So that's my thought, is we are allowed to look at the gray. This is a gray thing. I mean, yes, it's unusual to, we're usually trying to do something different, or not even trying to do something different. We're just trying to line up homes. That's the intent of the code, is lining up the homes. And this is not lining up the homes. And so what's the point of having our board if we can't judge on these gray matters?
Well, I agree that we have discretion in variances. An IMA appeal to me is an error of law. That's where, if it were in the variance category, then I'd feel like, I had more leeway. So.
Yeah, I understand that.
Yeah, I'm just explaining it to you so you understand.
No, I understand.
Your neighbors.
Your outlier now knew what was there, was aware of it, and elected to go there knowing what was going to happen. So he brought himself, he, she, it, whatever it is, brought itself to where we are today, caused and created, whereas we're trying to maintain, at least I'm arguing that, and I'm having a hard time doing that flip, because normally I'm the very strict by the line type, and it's just hard for me, and I can't go there. So I wish I could. Normally we agree almost all the time and that stuff. But is anybody going to call? Because if not, I'm going to.
It's a very hard case. Like I said, I wish there was something I could do for the neighbors. Well, is there any more discussion? We've got Mr. Wallace's motion is to find that Mr. Hargis erred.
Joey screwed up.
Yeah.
I wanted to put it that way just because I could.
Okay, so all in favor of the motion that the zoning administrator erred, say aye. 3, all opposed. 3. So we have a tie. I think that means.
I would look to the zoning administrator to confirm that, because under the code, you have to have 4 affirmative votes to pass a matter, that this matter is now denied by operation of law.
No, actually, in this case, this is a tie vote under our rules. It'll stay on our agenda for the next 30 days.
Okay, it'll be on the next agenda, and actually, we expect that we'll have another member present.
What can happen, no new evidence comes on the record. So for all parties, we can't email the board.
Oh, did he just dodge a bullet?
But the case will be on our next, which is
May 19th. Which will be back at the other location for all the neighbors. It'll be at the Sunny West Conference Center at May 19th at 1 p.m.
Potentially June 2nd. The 7th member of this board, which will be confirmed tonight, may choose to participate. The board members who participate today are allowed to change their vote at the next hearing. If this vote stands tied 3-3 after June 2nd, or the seventh member votes one way or the other,
But
sorry, for clarity's sakes, let's just say the seventh member doesn't participate and we stay 3-3. The motion will fail. The zoning administrator's determination is upheld. That'll be the default position.
there will there
Remind me one more time, pretty please.
On a tie vote, the motion is to overturn the zoning administrator. That motion would fail if no one changes their vote and the seventh member doesn't. If you don't get 4 affirmative votes with your motion, that motion will fail. The default position is the administrator.
And there will be no discussion at the future hearings of this. Okay.
So the record in this case is closed.
So at the next meeting, it's really on the new member or someone changing their vote, right?
That's correct. Yes, sir. And process-wise, Ms. Waits will poll the board members who participate in this case. Do you wish to change your vote first? Then she'll turn to the new member. Have you watched it? Do you wish to participate?
May I ask a procedural question? So if we had voted to uphold and it was 3-3 without sufficient votes, would then your decision have been overturned?
No, it would still stand because the permit has been issued. The default position is the administrator got it right. The appeal is, hey, the administrator erred. So, I mean,
I was just seeing if it flipped it.
No,
you know what I was doing.
I do, yeah.
Okay, thank you. Why don't we take 5 minutes before 5 to 10 minutes before we start the next? We'll take 5 to 10 minutes.
The next case on today's agenda is case number 2022-41. This is a request for variances from the side and the side street setback requirements for 2 single-family dwellings located, or actually, I'm sorry, it's actually a 2-family dwelling. Yes. Oh, 40.
42.
Case 40 was actually on consent. This is, yes, my notes, this should be a 2-family dwelling on 106 Claiborne Street within the R6A zoning district, so it's a duplex. The applicant is requesting to reduce the side street setback, or the side setback from the neighboring lot. So the neighboring lot along, this is the aerial photo of this area, so it's a corner lot between, it faces Claiborne, and then the side street is Fane. There's a picture of the house, or the existing duplex on this property, which is one structure. The site plan's going to separate it into 2 individual dwellings. And then this is the view from Fane. And then at the bottom, you've got a view of straight on from Claiborne, as well as with the couple of neighboring properties there. Here's a few more photos of this area as it exists today. The one on the top is a view from Fane toward looking at the streetscape on Claiborne, and then the one at the bottom is the length of the property along Fane, the side street. So the applicant's requesting to reduce the side street setback along Fane, which would normally be 10 feet. They're seeking an 8-foot side street setback variance. On the other side of the property, where the property line abuts another house on Claiborne, they're asking to reduce that side setback from 5 feet to 3 feet. And they have maintained the contextual setback from like the street setback, so there's no request about the street setback, it's just the 2 side variances. So is there anyone here in opposition to case number 2022-41? Okay, seeing none, the applicant is present. Okay, please come forward and you'll have 5 minutes to present. Please let us know your name and your address.
I am Caitlin Jones, 302 West Mill Drive. I am here on behalf of my friend Denise Battles, who couldn't make this date as it was deferred, her original date from a few weeks ago. So I am here. Thank you all for your service. I think she asked me to come as I'm very experienced with public meetings, as I'm a 5-year commissioner on the Metro Historic Zoning Commission. So items like the ones you just did, a little bit of PTSD for me as a commissioner, because we've come to a couple of those that are very hard to answer. So I really appreciate the work that you all are doing on this board. Again, as they presented, it is currently a duplex. My friend is just wanting to construct 2 moderately sized homes on the lot. As you can see, the current structure is hitting in that one setback, the off-fane already. And so it's really just she's asking for these numbers can move. Again, that's just where she put them on the plan, or really she just wants to be able to use 24 of the 35 feet, and wherever you all think, again, that's her request, so those numbers, they're kind of arbitrary, as far as the 8 foot in the 10 foot, 10 to 5, and then 8 to 3. So that is her request. And otherwise, I feel like it's pretty straightforward, so thank you.
Okay, thank you. Any questions?
Yes, what would you consider the hardship for this?
Oh, well, the hardship is, it is, because it is on a corner lot, it has larger setbacks than non-corner lots.
Fairly narrow lot.
Yes, it's a fairly narrow lot, I believe, and again, the current structure, as you can see in that shaded area, not how to read a site plan, but it's already in that one setback. The existing residence is actually further than where this one would be on that one unit in particular, and so that's it. So it's really just that the setbacks are larger as it is on a corner lot.
So what's being proposed to be built is the new structure will be pulled back further from the street than the existing.
Correct. On that one, but both of them actually, yeah, but the existing, correct, yes.
Do you know if there's been any conversation with the adjacent neighbor there on Claiborne?
I do not know.
Okay.
I do know that she reached out to council member Freddie O'Connell of this district several times, and he didn't respond. But I do not know about the neighbors.
Photo, it looked like the neighboring property was a newer build, but I'd have to look at it again if we could see the photos. Yeah, I don't know.
Again, these are pretty, like you said, a pretty narrow lot. It's on the corner. And again, these are for 2 moderately sized homes. For the neighborhood, I think they're sized correctly for the neighborhood rather than having one long, skinny duplex structure on that lot.
Do you know if they're 1 or 2-story dwellings?
They are 2, or one. Yes, it's a 2-story dwelling. I don't know the square footage, but just a small. Looks like both of them are. I guess this wasn't included in your packet. What I have here, I don't know how to present to you, but. They are 2 stories.
Would you say that probably around 1,700 square feet?
Yes, I do believe so. Yes, they're small. The second story is solely a master bedroom and a second bedroom, and then the downstairs has a small, living area, kitchen, and then a small bedroom or office down there on the first level.
You know if the intent for this is short-term rental?
I do not believe she as far as I know, her plan is to keep one, potentially reside there or have a long-term rental, and then potentially sell one. So I don't know about if once it gets sold, but that is her plan for it. But I don't. She hasn't expressed to me an intent to short-term rent.
Do you think if there was a condition to prohibit that, if there would be any opposition from her?
I don't believe so.
May not even be an
I don't
option for the
believe so.
zoning, I don't know, but that's just,
Yeah.
want to hear that from you. Okay.
I don't believe so. And again, just really, ideally, she's requesting to use, 24 of the 35 feet in any way, that you all may deem appropriate, or not, of course, but that is what generally her request is, not necessarily the exact numbers. It's just kind of to fit these two, again, small, I think neighborhood-sized homes on this skinny lot.
Questions for the applicant? Okay, we'll close the public hearing and discuss.
Member Newton, in page 129 of that packet, there was a opposition from a person across the street.
I saw that, and I looked up where that, I don't think they're talking about this house. Maybe I'm wrong, but it said, looks like they're not, I don't know, maybe I'm wrong, but the way that they were describing the connection to theirs, I don't know if their understanding is which property that it's under question.
I read it as if they did, and maybe they have they're using incorrect terminology, and but to this letter's point, there is, for it to be such a small but also narrow lot, there's a lot of building on this lot, and they're trying to put even more building on this lot, and I get their cause for concern. And I asked about the short-term rental just because that typically involves, more cars on the lot, more parking. The next thing you know, now you got cars in the street,
Not to mention the intoxicated bachelorettes.
Yeah, the woo-hoo crew, right? So, yeah.
So I didn't even think about the short-term rentals because I didn't really care. My main issue was that this is an existing duplex, but it's an existing duplex that has like a small footprint. Like this is, and I don't think there's a hardship. Like this lot isn't any different than any of the other lots on this block base. All of these lots are narrow. So there's not a hardship. It's just simply, I want to build two, and maybe this lot, see now, Mr. Newton, this is where I would go to my certain courses and certain horses.
Okay.
Because
I was waiting for it.
This is a very small, narrow lot that we're now trying to put two houses on, and I think the base zoning allows it. So if the base zoning allows it, build it to code within the base zoning. But essentially, you're coming to us to manipulate the setback so that you can fit both of these homes, and that's where I take an issue. Maybe this lot isn't big enough for both of these. Maybe it should be a shared wall duplex. Maybe that would allow them to build the two residences within the footprint. But at this point, I don't see a hardship. And so it's going to be really hard for me to support it because I just think we're trying to put something that maybe this lot wasn't designed to hold.
So I just wanted to respond about the zoning. These are actually non-conforming lots because all of these lots in this neighborhood are about 5,750 square feet, and they're R6, so they are not big enough to duplex. This one is eligible to duplex solely because of the existing non-conforming structure, which is a duplex. So.
But it's a shared walls duplex. This wouldn't be a shared wall duplex, right?
That's correct. I just wanted to clarify that the zoning in the area actually does not support duplexes, but this specific lot can.
I've got while you're there, so when I look at the bulk regulations and I look at the maximum building coverage, and so these two homes are not exceeding the allowable maximum building coverage for this property, correct?
I don't know. I haven't looked at that. I'm sorry. But I can say that there is a lot of space on the site plan between the two structures. So I would tend to submit that there may be some other configurations, particularly perhaps on that side street between the two houses on Claiborne.
It looks like R6 allows about 50% of the lot to be built, and we can probably eyeball it from here to But I think that would be before us. If there was an issue with it exceeding the maximum building coverage allowed, that probably would be before us.
Right, that's why I have not looked at that for this property, because it isn't.
Not before us.
You know, it is not before you, but, so the only request that's been made is just altering those setbacks, and I did notice from the site plan that the houses, you know, are a little bit farther apart. In other words, there's some space in between that, you know, potentially could also be used for some of the bulk standards.
Just scaling from the plan presented to us, it looks to be just under 30% building coverage based on the plan, those, you know, roughly. So, yeah. And to Ms. Davis's point, this is one where I do agree it's a smaller lot, but the fact that there is a duplex, well, that obviously gives it the opportunity, but also the fact that it's on 2 streets. You'd have, you know, I think that makes it more. I mean, if this wasn't on the corner, I don't think we'd be looking. I think I'd have to be very different feeling on this. Yeah.
You're saying, okay.
Yeah, but with it being, you could have one facing one street, one facing another street. It makes more sense to me as far as creating a good streetscape to do this versus maybe a more interior block.
But can't they do that without the variance? I'm asking, I don't know.
It's the narrowness.
It's the narrowness is the variance, and so they, you know, their existing structure is obviously within the setbacks that are there in place now. You know, I think I have a hard time pushing them any more restrictive than the existing structure is. So I think it's 24 feet. That's a pretty, you know, modest and not excessive width of a house right there at all. I mean, that's kind of your not your minimum viable, but it's pretty close to it. With that being said, we're not necessarily looking at can they build a duplex, because they can do that. We're looking at where the duplex goes on the lot. That they could build, if they wanted to, they could build longer and skinnier duplexes that I think would not be as good of a product, good of a streetscape, all that kind of stuff, without getting any variances technically. But
that's not a hardship though. So, you know, they can still do something, it just won't look as nice. I mean,
right.
So well, I think to me that's not a hardship.
That's fair.
And pushing it further back, you know, now you're encroaching on the neighbor. Like, I would be more inclined to say, I guess, push towards the street if we're not going to honor that.
Yeah, I would be okay with essentially putting the setbacks where the existing house is now, which looks like a 5-foot setback from the neighbor, which is that's by the code.
That's what I think I was more concerned with. I had less concern with Fane because there wasn't anybody there.
Yeah.
I don't.
Right.
This house already looks pretty close to the neighbor.
It does.
And it seems like giving another 2 feet, that just seems.
Especially if you factor in the setback encroachments of the eaves on the house and things like that.
So that was my main thing.
Well, then, I mean, does keeping the 5-foot, denying the request for 3 foot, make them do 5 foot, and then doing maybe.
You were talking about moving it closer to Fane.
Yeah, essentially,
and
2 feet closer
the
there.
Existing face of
and then they could keep the same footprint.
Yeah, because that's where the existing structure is right now.
Okay.
Okay. So you have a motion.
All right, I'll make a motion that we deny the request for the 3-foot setback on the north side, but approve a setback of what is that?
12
Probably
would be 12.
No, it's going from 8 foot to.
Oh yeah, 10.
No, it's they're asking for 8. It would be closer to. God. Hold on, it's the longest motion ever. Scale it as best I can here.
Well, it's a 35-foot lot.
Yeah,
And
so.
they're going to have a 5-foot setback from the side, so that gives 30 feet.
So.
20, so it'd be a 6 6-foot setback, street setback.
Would give the same dimensions that they
Okay,
were seeking.
6 foot, okay.
6 foot, 6 foot setback on Fane.
Yeah.
Okay.
Does everybody understand that?
Remember,
No, go ahead.
not Wallace.
Call me Logan.
Do you want to put some type of stipulation in there about?
Yeah, I think that's a fair point, yeah, that not be allowed for short-term rental on this property. As long as that's a motion, or as long as that's a condition we can make, which I believe it is. We've done that before.
I think it is. I think we've made it before.
And I think we should look at the zoning ordinance, or sometimes the HOA will include that language, but I'm not sure the board can make that decision if
I do think I remember trying to make that on one a couple months ago, and Joey told me we couldn't do it.
Got slapped down on that?
Yeah, I got that slapped down.
Okay.
All right. So
Well, I guess I will remove that portion of it then. Yeah, right.
Okay. All right, so there's a motion. Is there a second?
Well, I'll make the hardship being the existing location of the structure and the exceptional narrowness of the lot.
In the corner.
And being on the corner, yeah.
Okay.
Yeah.
Okay, is there a second? Second. All right, all in favor, say aye. Aye. Any opposed? Okay, congratulations, that passes 5 unanimously.
Yeah.
where are we now?
43, I think.
Next case on today's docket is case number 2022-42. This is a request for variance from the setback requirements for a single-family dwelling located at 4421 Lone Oak Drive within the RS 20 zoning district. The contextual setback by average of the nearby properties is 78.2 feet, and the applicant is seeking to build to the 60-foot platted setback. Before you here is the zoning map of this area, the aerial photo, the lot as it exists today, so there's an existing structure on the property, photos of the streetscape, and the survey. So is anyone here in opposition to this case? It doesn't seem that there is. There were 2 emails that were submitted in opposition. Certainly we'll hear from the applicant. I just wanted to explain quickly that one of the gentlemen that had emailed in opposition also emailed today indicating that he had been working with the developer and was requesting some conditions. And because that email was received by me just earlier this morning, I printed a copy of it and was going to give everyone an opportunity to read it while we ask our applicant to come forward. Okay. So if you'd please state your name and your address, and then you'll have 5 minutes to make your presentation.
All right. Good afternoon. My name is Taro Larocco, 1023 Seymour Avenue. I'm here on behalf of the homeowner, Chris Harwell. And what we're asking for is to build to the, or to be able to build to the 60-foot platted setback. The hardship.
Can I interrupt you just so I can get this straight before you go on? The existing structure is at 64 feet setback, and you want to build to 60, is that correct? So there's a 4-foot difference, is that what I derive?
What we have, if currently we would need to build to the contextual setback, which the current house is encroaching into roughly 14 feet. So it even further restricts our building envelope.
Okay.
More so than what
the existing residence is 64 feet.
Yes, and the dotted line that cuts through the middle of it is the contextual setback. That's.
Okay, and so where are you asking you to build to outside of the building envelope? I mean, with respect to
the plat is at 60 feet.
What's that?
The plat is at 60 feet.
So 4 foot back.
So we're asking just to.
So it's 4 feet back. That's what I was trying to get at.
Correct. That existing house is going to be torn down. It's a 1,400 square foot ranch.
And so the house you're going to build will be 4 feet closer to the street?
Correct, that's what we're asking for.
That's what I was trying to get. It looked like a 4-foot difference from where the existing structure.
Okay, yeah, I misunderstood the question.
It takes me a while. So.
All right, I was trying to follow too by looking at it that way, so.
Yeah, the current envelope right now would be extremely restrictive. The footprint of the existing house, it's a 1,400 square foot house with a carport. So, and you can see how difficult it would be to even fit that in the new building envelope imposed by the contextual setback.
Any questions for the applicant?
I guess if the board were to decide that maybe the 64-foot setback to align with the existing residences is more suitable, would you have any strong opposition to that particularly?
No.
Okay, thank you.
And your hardship is that it's the shape of the lot?
Yes, it's the shape of the lot, and if you go to a slide that shows like a broader view of the neighborhood, like an aerial view, all the other lots to the west are much deeper, narrower and much deeper. Our lot is actually, it's long and shallow. We originally tried to get a frontage established on Belmont Park Terrace, which typically lots are narrower and longer, or narrow and deeper. But because of the established pattern of all those houses to the left, zoning felt that was, or planning felt that was inappropriate.
Have you read these conditions? I have not yet.
Yeah, looks like Mr. Clay Petrie, he had provided some opposition originally, and then he sent an email essentially saying that he's kind of retracted a little bit of that and says he thought, as he understood it better, and says that I'm going to paraphrase, but essentially he's okay if it's built back the same setback as the existing house that's there, which is
yes. I've been in conversation with him, and I believe the initial opposition was just a misunderstanding of what we were asking for. It appeared to him that we were asking for like a 14, 15 feet in front of the existing house, rather than some alleviation from the contextual setback.
Okay, any more questions for the applicant? Okay, thank you, sir. Appreciate it. We'll close the public hearing. And there is no opposition, or is there? No, okay, no opposition. Okay.
Well, I'm very familiar with this corner. It's on the route between my house and my parents' house, so I have driven it many times and grew up near there. So I think the existing house is pretty well in line with the other houses in the neighborhood, and it does kind of maintain that contextual line. Even though it's, maybe the averages are a little bit off, and it's kind of the curve of the road, and it's got two slopes on this lot, so I think there is a hardship there due to the topography of the lot and the existing lot size, or the existing lot shape. So unless I see anyone else want to talk, I'll make a motion.
Yeah, make a motion.
We approve the variance at where the existing house is, and all around at the 64 feet setback due to the hardships I mentioned of the topography of the lot and the unusual shape of the lot.
Okay, there's a motion, a second. Any discussion? Anybody? Okay, all in favor, say aye. Any opposed? Okay, that passes. Congratulations.
Thank you.
Yep.
Member Lawless, you haven't asked about trees today at all.
I know, I left that one alone this time. I figure he's going to throw a couple trees up there, if not. Mr. Petrie, I'm sure will be upset with. We've got several more opportunities for me to get into tree mode.
The next case is 2022-43. This is a request for a special exception for properties located at, it's a horizontal property regime at 1907 B, C, and D Herman Street, or I think the D lot is also named 1916 Britt, which is the street on the backside. It's a through lot. This property is zoned CN, and it's otherwise in a predominantly RM20 zoning district. The applicant is seeking to waive the landscape buffer requirement under the adaptive residential development section of the zoning code to build a two-family residential dwelling. Before you use the zoning map, and then we have the aerial picture of the surrounding area. Here's the current lot. This is a narrow lot. It's 20 feet across. Here's some photos of the streetscape. It's residential, and then here is the site plan that's been submitted. I've got some notes here about the land use policy for adaptive residential development, which is to increase residential opportunities in non-residential zoned parcels. So in this case, unusually, it's actually just one CN zoned parcel within a residential street. And then just another note about the policy for landscape buffers normally would be to minimize the impact of incompatible zone districts, whereas this is a request to basically use the property for residential purpose. So is the applicant, or is there any opposition present on this matter? Okay. And then the applicant is present as well. So if you all will come up, you'll have 10 minutes to speak. You might want to reserve some of your time. Then we'll be happy to hear from you all neighbors that are present as well afterward. And so, and then you can also speak at the end if you wish to. So if you would please just speak into the microphone, tell us your name and your address, and then you'll have up to 10 minutes right now, but you may want to reserve some time. No, that's fine. We'll hear from whoever's here in support of this application.
Okay, thank you. All right. My name's Paul Simu of 146 Southwest Drive. This is my business partner, James Feynman of 1728.
Yeah, 1728 14th Avenue North.
Correct. And we're requesting a waiver of the landscape buffer because with the CN zoning abutting a RM zoned lot, I believe there's a minimum of a 5 or 10 foot landscape buffer, which is usually used if there's a commercial building that's abutting a normal residential house. That's what that's for. But here, with us building adaptive residential, we're wanting to put 2 residential units on this parcel, and we're not building anything that would be a commercial use. So that's why we're asking for the waiver of the landscape buffer, because we're building residential in a community that is all residential. So it's a really unique situation here because with adaptive residential, I believe the minimum is multifamily is what you have to build. So what Joey Hargis had told us when we submitted our permit and we talked to him on the phone is that by law or by right, we have to build 3 or 4 units on this parcel, which is like pretty crazy because it's only 20 by 150. So we're trying to build 2 instead of 4. So we do qualify for adaptive residential, which is not what we're denying or appealing. We're appealing that we have to build what's considered multifamily, which is 3 or 4 units on this parcel. 1, because that triggers a grading permit. 2, because we don't have the parking for that, and 3, because that's not in context with the neighborhood. So we're not planning on building any skyscrapers or anything big. We just want to build 1 or 2 family instead of 3 or 4 family, or instead of what's considered multifamily, which is what adaptive residential makes us do by code, which is what we are appealing.
So if I can ask a question, what you said the residential, what, like, are these going to be sold? Are they going to be rented? Are they going to be short-term rented? Like, what's your plans for these units?
My plan is to live in one of them, and his plan is to rent the other one out. So this is a JV venture where we're going to keep it. We're not going to.
So like short-term or long-term rental?
Long-term.
Okay.
Why not rezone it?
So we thought about that, but with rezoning it, it would be a longer process than just trying to get an appeal for the landscape and for us doing 1 or 2 family instead of multifamily. Because by right, we could do 4 one-bedroom units, but we don't want to do that because that's not something I want to live in. So.
Go ahead.
No, but also, you're talking about by right, but you're coming asking for an exception. So I always caution people that I'm going to go ahead and warn you against that line of cautioning because, like, we've heard adaptive reuse cases before where people want to do something different than what the zoning allows. At the end of the day, you're asking us for an exception. So I don't want to hear a lot about what you can do by right because if you rezoned it, then we wouldn't even hear this. So I just want to warn you against that.
Correct. Yeah,
so,
absolutely.
Okay, so I understand. So I'm sorry. Go ahead, Mr.
Thank you. I jumped in too soon.
He may have wished you did.
Well, maybe so. Okay, I'm just trying to get my. I don't know how long you've had this property, but do you have any idea? Like, it looks like this is a CN zone in a sea of not commercial zoning.
Correct.
Do you have any backstory as why it was CN zone in the first place?
There was a barber shop that was there before years ago.
Okay.
And that was before the community character manual was adopted that allowed for adaptive residential.
Okay.
So there was a barber shop that was there before.
Gotcha.
Correct.
Okay, that makes a lot of sense.
Which is why, which is the only reason why we had bought this parcel because we knew we could build residential on it. Instead of being limited to whatever commercial use that there was.
Yeah, I had a project that was, it didn't go through, but it was an adaptive residential. And my understanding of it from the planning department, and I don't want to speak for the planning department, and I don't think it was mentioned in their letter, but my understanding was the adaptive residential provision was created to allow residential uses in a commercially zoned district. So that would be the reason maybe why they didn't go for the rezoning. And this is just my understanding of it from learning about it from the planning department.
Any more questions for the applicant? Okay, thank you.
I have one more question. I'm sorry.
Oh, yeah, go ahead.
How many square feet for each? I can't really tell. I'm looking.
Each unit has a base square footage of around 800 square feet. So there were maybe, I think we're around 1,500 to 1,600 square feet with the 2 stories that were provided.
Okay.
So, right.
That was it. Thank you.
Okay, you probably have some time left on rebuttal. So we're going to let the opposition speak, and then you'll have whatever remaining time.
Thank you.
Should have at least a couple minutes, I would think.
If you just tell us your name and your address, please.
My name is Amanda Covington. I live at 2005 Bridge Place for 25 years. Thank you, Jesus.
My name is Miss Beatrice Nichols. I live on 817 21st Avenue North. I've been living there for 50 years, over 50 years.
Amen.
Really say I was born in that area, okay?
I come today because everything on my street, I done saw it built. Everything. I was over there every weekend. I'm the oldest, I found out today, I'm the oldest living person that purchased a new house over there. The lady was the first one. I found out she died last year while I was in the hospital. And I was very upset. I got to go to a house sometime this weekend. But I'm the 3rd person that bought a house over there. I love my neighborhood. I mean, I had 3 different addresses since I've been there. At first, up on the other end, 21st, between 21st and 25th, I grew up a little bit up that way, but I came back. But anyway, This getting to 1907B Herman Street. Herman Street, I can sit on my front porch, which I do every time the sun come out. I sit on my front porch, that's all I can do, and play with my flowers. Everything that's been built over on Herman Street, I've been there to see it with my eyes. The last 4 things were built beside these 3 storage buildings, which is short term, but I call them Airbnb, because a single family is not a 3 storage building. They cut a fence, they put another, the 2 little in the back, they put in the backyard, 2 doors down from the church. I live right in the back of a church, Galilee. They cut a fence that runs straight down my street. They cut a fence where they put this 2 storage, 3 storage, whatever you call them. I call them Airbnb. They just recently did this too last month. To open up, they called it Brick Place. But it was the church. The church house is white. The other brick building belonged to the church. It never been but 3 houses, and they still there. And they brand new on Brick Place. Rhonda Dow, this other white man, I don't know the 4 white people live on my street, but I don't know everybody black. And then my used to be insurance lady, Miss Annie. That's the only 3 houses on that part of Brick Place, which this young man just stated that 1916, that's the little thing used to be our barbershop man. It's bad enough to put a single house. Let's put 2 houses, I heard him state, in that, which cut the fence again and bring it to Brick Place. And I want to see this, because I'd be sitting right there on that porch to look at it. Me and my coffee. Anyway, make a long story short. Brick Place run between 19th Street and 21st. I sit on my porch and look at her house every day. That's how close we are. On that side, Galilee got it from 21st Street to halfway past my fence, because I got private fence every time we run my yard. Including their 2 houses, that's a little bit down further, where they put this Airbnb to cut the fence that came to Brick Place. All the way down, there ain't but 1 old house on my house, on my street. I'm a nosy person when it comes to my neighborhood. It ain't but 1 old house, and the mama and the 2 sons is dead. And it's a rental property. And that's long from 19th to 21st. And I'm on this side of it. It was only 12 new houses built. And that old house back in the 50s and 60s, when I was a little girl running up down that alley, because it was Batavia Alley. Then it was Cabby Court. Then when Reverend Britt died, they named it after him. That's the history I know. But all that added stuff for the Airbnb, I done sit down and watch them put from 21st to 28th. These big old 4 storage houses and stuff. Bought 2 lots, put 8 houses. They so close you can do your hand like that. Over here, this last house they put up on this side, but they cut the fence. There was Brick Place right there. They cut the fence to open it up. Put the apartment, or whatever you call it, 3 storage, put that on the inside, on the backyard, and it's a B right here, A and a B. 2 apartments right here, and the other part is on Herman Street, which is I did my homework, 1907. That's on Herman Street. Maybe I'm a little confused with the letter right here, but the ones I'm talking about is on Herman Street by the church. This little bitty thing right here is about wide as this, maybe a little bit wider than this right here. That was our old barbershop man. Right next door to the Crowder. That's where that lot is. The Crowder family, 1909, is the Crowder family. And then it's that little bitty, it may be a little bit wider.
It's showing up now.
It looked just like I got cataracts. It looked just like that, just a little strip you just ride a bicycle through. It ain't big enough to build no house.
Not no 2-story.
Like I say, I'm nosy. Only way they can get 2 little Airbnb or short term, they got to put 1 in the front yard and put 1 in the backyard and cut the fence again. Because Because part of that yard is the Crowder. I went by there this morning. They done already cut their yard. That side by where they go in the kitchen door, that's how well I know these people. Where they go in the kitchen door, they done cut Nathan, that's the brother. He done cut that side of the yard. So that ain't part of that little land strip. That's not part of that. Now, the Crowder was trying to buy that, but they didn't think that the value of it was too high for that little strip. Because that was our barber shop a long time ago, the little barber shop man. That was that, but the Crowder lived right next door to it. That's how I know so much about that land. And that land had never came over to Britt Place. Not since I've been there, not when I was a little girl, and I'm old now. It's been a long time since I was a little girl, because I can't run no more. But that land been there forever, you hear me?
I hear you.
It's bad enough to put one building, which they put these 3-story things. I don't know what you call them, but I know they're short-term and Airbnb. Because that's where the white folks came in our neighborhood. Every week, if I don't go to church, I'm sitting there. I'm right in the back of the church, so I see everybody going to church. I know everybody over there. They kin to me. And you cannot go from Brick Place to across Herman Street because we got this long green fence all the way down to 19, all the way back up, except leave the church out. But it's in the back of the church where I live right in front, in the back of the church. It ain't nothing about that neighborhood that I don't know, but she knows 50 years of it.
So, ma'am, can I kind of, I want to make sure we're all understanding this, what they're asking for here correctly, just because like I'm trying to understand it too. So, and I do have some recent. I was through this area recently because I went to a funeral down in Galilee for an old high school teacher of mine.
I'm not paying you that.
You know where Galilee Mission is?
I was just there a couple weeks ago for
well,
funeral of Mr. Paul Eldon Bass. Yeah.
I see him there.
You passed by that little thing. That's how it look, ma'am.
Yeah, he passed away recently.
That's very sad.
Yeah.
And I'm wondering if it would help if we saw the photo of this area. Would that help?
Yeah, maybe it'll help us to get the photo. So, so what these gentlemen behind you, they can build right now by law.
I know that.
Yeah, well, but they can build. And I know it's a narrow lot. I know it's a very narrow. I was kind of I took note of that when I was walking down there to my car. So they can build.
Well, see, that's Herman Street side.
That's right.
It's no Brick Place to that land.
That's right.
How do you take? How do you take, sir? How do you take a Herman Street side and cut the fence and make it Brick Place? And show me how is that right?
So the property we're looking at is a 1907B Herman Street.
Right.
So that's what we're looking at here.
Right.
Okay. So
but this 1916, that'll be on that other side. It ain't no land on that other side, sir.
We're only looking at 1907 Herman Street here. That's the only one we're looking at.
Okay, because there's no land on that other side. I know that street.
Gotcha. Okay. So by law on this property, they are allowed to build 3 or 4 units, which I know that's way too many. And what they're asking to do, they're asking to build less than that. And their plan is, this gentleman said, in their testimony said he's going to live in one, they're going to rent out the other one. So they're trying to build less than what they're allowed to build, and they're actually required to build a certain amount. They're trying to build less than that is what they're asking for. Okay.
But they can't put it on Brick Place, sir. Now, that's the law, too. That's on Herman Street.
That's right.
That's his lot.
That's, yeah. So,
but the back part will have to be in the backyard.
Right, yeah, so I would assume...
only way they can put it on my street if they cut that fence again.
Yeah, well, the fence is on their property, so they can cut it if they want to.
Yeah, I know that, too.
Okay.
Because that's the Crowder house right there where the ramp is, going to the back door.
Okay. So,
I understand you, sir.
Yeah, so I'm just trying to make sure we're all understanding the same thing here. So they can build 3 or 4 units. They're trying to build less than that. The only thing they're asking for 2 things. They're asking to build less than they're required to build, which I think you all would support, being able to build less than what they're required to build. Is that fair?
The only is that here where I'm
Okay.
checking is the idea they building all these skyscrapers when there's a neighborhood for homes.
Yeah.
That's
They
what
were
I
single home back then.
Yeah, that's why I don't get it.
Any of those homes right there, they single home. I know those people.
Yeah.
On the other side of the street, they single, they old home. They are old in the 50s and 60s, but they single, except for that mess up the street and that.
Yeah, they got skyscraper all in the neighborhood. It's not gonna feel like no home number. They're like they're crowding.
It's a mess. It's a mess.
Then all these skyscrapers.
It's a
in
mess.
neighborhood
I don't
should be
believe, I
homes.
believe they're gonna tell another lie and build it where they can take and do short-term rental. I don't believe nothing they saying. Now, I hate to say it, but I'm for real.
So, question, we see in our packet, we have quite a few letters from people that are opposed to.
I can't hear you, sir. Thank you,
Right
baby.
there, ma'am.
I'm
So
old.
there are quite a few letters in opposition, and one of their main points are they don't want short-term rentals in this neighborhood.
We got it over there already.
Is the opposition building a home on this narrow lot, or is it the fact that they may use it for short-term rental?
Use it for something else.
Okay. So if they build a house on it, you all are fine with that. Is your
A single-family house.
Right.
That's what they require in my neighborhood. I got all kind of work. You know those little containers you put tops on them? Lid, I love them. I got all kind of zoning and stuff. I live in that neighborhood. I got to have it, sir. I'm not trying to be mean or rude, but I got to know what the law require me to do. If I want to add on, what is I'm gonna do? Can I change my, wait, Miss B, can I change my single-family home into a short-term rental property and put another big building in my backyard? Because I got a big house and I got a big yard. Can I do that? If I come back before you all, the request, if I decide, since I'm almost 67, can I request, if I want to take my house and turn it into a short-term renter and build another house in my backyard?
I think Miss Elizabeth over here can, you could go meet with her at the codes department and you could answer that question after looking at the zoning.
As far as, yes, the property, I'm not sure about her zoning. It's probably RM20.
Because I got more land than that, baby, even in my backyard. I ain't being mean. I'm just telling the truth. I've been sitting here ever since 12:30 waiting to speak. But I'm just telling the truth. I'm telling you because I don't lie. I heard that young lady right there say
I'm sorry, I just wanted
to
you
lie.
to, you probably
I'm
have
just
30
telling a
seconds for
lie.
that.
I got more land right there in my backyard than they got.
You wanted to be heard, yes, ma'am. You have about 30 seconds from now.
Now, I know a long time ago, since I've been in my neighborhood over 50, 60, over 70 years. And I don't know why the zone has changed. It used to be you can't build no house for this far apart. Now you can build a house this far apart. And that don't make sense. I don't understand that. Why do you have to build everything so close together? Anybody can answer that question?
Well, I can say we didn't make those laws.
I know, but y'all is a committee that y'all can make sure everything should be like it should be.
Well, as
Instead
Ms.
of having
Hartnett
everything
said,
so far.
We'll do our best.
if I get your email, then I would be happy to have a conversation.
email.
Okay, phone number
We got my address.
Yes, because I want to make sure, I know before the board is like this question about whether or not they can have some relief on their landscape buffer and the use on the property under that zoning provision, but we would be happy to discuss with you further just kind of some of the provisions, some of the changes that have taken place, because I do definitely hear and understand your concerns.
Because it don't make sense. Like if it's a fire, whole neighborhood be gone. If it's a tornado hit, the whole neighborhood be gone in that area because houses, everything is so close together.
Yeah, so we can talk about that too, because there, yes, I
Everything
understand.
is
There's changes in the fire and the building codes, so.
It should not be. I'm gonna tell you like it is.
Okay, so how much time does the applicant have left on rebuttal?
It was several minutes. Do you recall for the applicant? Oh, okay, so they have 8 minutes remaining.
Okay, so the applicant, you've got 8 minutes. Thank you both.
Thanks for your testimony.
Well, sir, I thank you for listening to me. I know the guideline may be to change from 25 years ago, But if code gonna be code, let it stay according to the law book. I saw that lady, I've been sitting here watching. I watch everything when I come somewhere to make my opinion clear. That lady got a code book. So if it's been changed, somebody done turned and opened the code book and rewritten it in order for the code to change. Is that not right?
Yes, that's Metro Council does that.
I thought so. Well, I hope I ain't waste my time, but I know one thing. I don't welcome nothing new to my neighborhood that's not according to the code that 25 years ago. Now, maybe the code have changed, but somebody opened up that book and rewritten that, and I don't think it's right to me. I don't see if any change that come in my life, because I'm rooting for 70, I'm going to see if the Lord let me stay up on Brick Place till I'm 70. If I decide to make a change in my life about my property, I don't see how much right Miss Covington got. Amen. I'm not being rude. I'm just real, and I don't tell lies, because I've been born again. Thank you.
Thank you, ma'am.
And I'm finna go home now.
Amen. Come on. We're going to get something to eat first, because we've been here too long.
Thank y'all.
Thank you.
Thank you.
Thank you, ma'am.
Food. The Sonic's better down here. That's the one I go to.
Well, I don't know how you're going to follow that.
I think that a lot of the concerns from her or other concerns that could have been brought up is exactly what we're trying to avoid doing, which is 3 or 4 units on the parcel. 1, for cost reasons, as that will inflict a grading permit, and 2, because we don't think that that parcel can support 3 or 4 as codified by law. So I think we all have sort of the same opinion here. I just think there's different ways of, or we had explained, got to explain it a different way to sort of explain that objective.
I got a question for you all. Not seeing Britt Place, I don't see it in the photo.
Britt Place is the alley that runs on the backside. That's the street, and all of the parcels on Herman run to Britt Place.
So the people who live on Britt Place are looking into the backyards of the people that live on Herman. Is that right?
Correct.
Does anybody live on Brick Place?
Yeah. Oh.
There's houses, yeah, all the way down the street.
Is it correct that the other side of Britt Street, the wheat side we can see right there, all of those houses face to Britt Street? It just happens that all the ones on Herman also face to Herman, so it's kind of a weird development pattern. Is that right?
Correct.
Okay.
So traditionally, the backyards on Herman would be empty, but because this whole area is zoned RM20, and when you have double street frontage, you can face it on either street, which is what she was referring to with 1917 Herman, which is a 4-unit STR development that was just recently completed, which is what I believe the bulk of her complaints were about, which I can understand that there's one house there, now there's 4 on that parcel, that now I presumably is now looking directly into her house.
So if I basically understand the position and posture you guys are on, is you really don't want any buffer, any green anywhere around you, simply because there's not enough space, I'm assuming?
The landscape buffer, I believe, that's required, I think it's 5 feet.
Yeah.
With the CN zoning, it's build to zone, so our site plan has a 3-foot side setback, which is typical with the houses that are there on the street and with the new construction.
I'm just trying to see what type of green, as my good friend over there already alluded to, I'm the tree person here. I'm sort of I like plants. I like something that gets rid of the yuck that's in the air. And I'm just trying to understand, and it's tiny. I wouldn't know where you'd put it either. I mean, I'm just trying to figure that part of it out. I don't think you can you?
Not on the sides.
No, not on the side. Yeah, so it'd be
You can't use that horse for this course,
Yeah, I mean, okay.
Any further questions?
It's a challenge for sure. It's a challenge.
Any further questions?
No, sir, I'm going to shut up.
We've got some questions for you.
How many stories will this be?
We were planning on doing 2 stories, contextually with what's been over there. We're not planning on doing 3 or 4, so.
Okay. All right, we'll close the public hearing. Thank you.
Thank you.
still can't.
Well, I'm surprised you can even build something. I don't know that I've ever seen a case where we had something being built on a 20-foot wide lot, and I'm surprised. And
We're trying to build less than what they can't build.
yeah, and I mean, I
I
think
don't, like, we keep saying that, could they feasibly even fit 4 on that lot? Like, everybody keeps saying that, I don't even think they could fit 4 on that lot.
No.
Like, I don't think that, I'm not giving them
Unless they
credit.
go up.
Go ahead.
Unless they,
You're going up.
You can go up.
unless they go
Okay.
up.
Fit 4. That's the only way to
Okay.
do it.
All right, thank you.
But how are they going to put an elevator in there? Because
You don't have to have an elevator for a.
For 3 floors?
No.
You have.
I'm not going to disagree with you. You're the architect. I'm just the
and there is no way for the side landscape. If you're going to build on that lot, you can't do the side. And I don't really know how you do the front unless you don't have any place to.
If you don't have anything in the front, you can put a car there. Now, I do recall us having a member of this board talking about narrow houses living in. So you can do it, right?
Woo, 14 feet. I don't know how you get the
like
stairs in
shotgun
there,
house.
and I don't know. I mean, I wouldn't build it personally. I live in a really skinny house, and.
Yeah, that's why, well, I was going to the expert on this particular instance. That's why.
But I mean, that's just my personal opinion. That's just not even relevant, really, to this.
Yeah.
But I mean, if they can build it, they can build it. It seems like they're allowed to build it. It's just if we allow them to have the landscape buffer variance.
Yeah, and I didn't really hear the opposition being about the lack of I understand her concerns. I totally get it. But I mean, I think what they would like us to try to stop, I don't think we can do it. And I don't think I didn't hear a lot of concern about the landscape buffer itself. Maybe I missed it, but.
She did, I think you're right. I don't think she said anything about a landscape buffer. I guess my question is, would a landscape buffer alleviate some of the obtrusiveness that people feel as these buildings go up on this small lot? I don't know, I'm asking the architects, but I know one of the reasons why we have landscape buffers is to create separation from sort of these buildings. So that's
Like from commercial to residential, and this.
But the thing is, like, that's what my issue with the adaptive rezoning. I say this on every case, which you guys probably already know. Where I'm like this on all these cases. If you want to use the adaptive rezoning, and then come here, this is a residential street. Like this has a context, and now they're asking us to sort of give them an exception. And I think if I'm going to give an exception, I just feel like. For me, I understand what you're about to say, Ms. Carpenter, so please make your point. But I do think a landscape buffer at least creates some separation. That's my only thing. Like, because you're going to be right on top of these neighbors because the lot's so small, which is not anybody else's fault, but that's my thought.
I'm not sure I was going to say anything. I'm wondering what you
No,
thought
because I didn't want to interrupt you. I think you have
just listening.
I totally agree with you about that. It would definitely help, but to me, it's a binary thing. I mean, you're either going to build on that lot and not have the landscape buffer, or it's going to be a vacant lot. I mean, I'll rely on the architects, but to me, the 20 feet was already. I was kind of amazed they were getting a house on 20 feet, but.
I mean, Member Lawless's point, would you rather have that vacant lot in the neighborhood or, some type of usable home in the neighborhood?
I know you don't. And you can't bougainvillea. I mean, I finally have been defeated in my plants on this tiny strip of land.
Well,
but something's better than nothing.
And I will note that in the packet there was one in opposition that had mostly to do with short-term rental, and there's one letter in support of this. That's from somebody other than the applicant. Maybe it may be their friend, for all we know, but there was at least one letter in support.
Well, Mr. Newton, you've been the motion.
Oh, great.
Yes, you have been the motion guru today.
I think Mr. Cole's got this one.
Okay.
I'm not. I'm leaning the other way.
I'll try here. I will say I'll move to approve the variance request because if the request wasn't granted, then the lot would be unbuildable.
I'll second. Okay, any more further discussion? All in favor, say aye. All opposed? Okay, so that passes 4-2. If we could take another 5-minute break. We'll come back to the next case, which
We'll
would
take a
be
quick recess.
44. Okay.
No, I get it. Single-family residence on property located at 1017 Preston Drive, located in the R10 zoning district. Applicant is requesting a 50-foot setback for a parcel currently within the lot is platted to a 70-foot setback. Preston Drive is a collector street, so the minimum street setback under the zoning code is 120 feet. The applicant's parcel abuts a parcel that was previously subdivided from a corner lot. So the neighbor's setback is different because it was set to a different street. It's like the block face facing Mitchell instead of Preston. So that was our aerial photo. Here is the streetscape. So they are pretty deep lots, and then the neighboring lot looks different. It was built to a setback facing a different street, even though the house itself faces Preston. So you can kind of see that a little better here on their survey, or this is actually the plat. So you've got 3 deep lots, and then the lots to the northern side were platted facing Mitchell, and then the rest of the block face has a lot shorter lots to it. Here we have the site plan where the applicant is seeking to put a second residence sort of in the front yard. This is some more photos of the neighborhood. And then this slide shows the contextual setback of this property and the other properties that we use to calculate the contextual setback based on the properties that are referenced, which are the ones that are facing the Preston Street block face and excluding the ones that face the Mitchell Street block face. Is there anyone here in opposition to this case? Okay, then seeing none, may the applicant please come forward? Thank you. You will have 5 minutes to make your presentation. If you please tell us your name and address.
Good afternoon, Board. My name's Richard Dauphiné. I live at 1017 Preston Drive, Nashville. And what this is about is trying to get a 50-foot setback to more aesthetically line up with the house that's on the north. The house she was talking about that was subdivided from the corner lot is at 50 feet 6 inches. And if I put it anywhere else in the front yard, it's just going to look willy-nilly as far as the aesthetics of the neighborhood are concerned. So I'd like to put it at 50 to keep it in line with the house that is on the north side of the property. That will also allow a bit of a backyard for the new residents. And I believe you have a proposed HPR. Do you have that available? That shows the maximum footprint.
So is the one that it would be aligned with, is it facing Preston?
Yes, it is.
It's facing Preston?
Yes, it's to the left side of the property, which is the north side of the property. That's at 50 feet 6 inches on my contextual survey that I had done. Now, originally I was told that any houses that were more than 3 times the minimum, which the minimum was 40 feet, any houses that were more than 120 feet were going to be thrown out. And without that, the contextual comes up to 56 feet without the deep houses included. And then they changed that in midstream. That's why I'm here today. After I did the contextual survey and ordered it, what took 3 months to get it done, then I go back in and discuss it, and he tells me, no, we've changed the rules. Now we will not throw out the deep properties.
That's the 156.5 property, is that what you're talking about?
Yeah, if you look at the contextual, let me look at it here real quick. Yeah, they were supposed to throw out, of course, my property, and then 156.5, 146.7, and 149.3. He told me anything over 120 they were going to throw out, and that we would just be dealing with the 50.5, the 62.5, and the 55.0. And that comes up to 56 feet as a contextual average, and I'm asking for 50 feet. But the main thing is to align with the property on my left side so it's geometrically, aesthetically pleasing in the neighborhood. I don't want the house to look just willy-nilly set in the yard, and to allow some backyard for that new build.
No, can you go back to the aerial view? So it looks like, just seeing the houses along there, it looks like, you know, the original houses are mostly in 1960s, 70s, something like that.
50s.
50s,
Yeah.
okay.
Mid-50s.
Looks like there's maybe one or two that have been added more recent.
Right, we got a brand new one 2 doors down that they split the lot vertically. That happened to finished up about a year and a half ago or so.
Okay, all right, thanks.
Any questions for the applicant? Okay, sir, thank you. We'll close the public hearing. There was no opposition, is that correct? Okay, we'll close the public hearing and discuss. Well, I look at this and think, how did we get here that you've got, you know, on one side of the property, certainly not on the applicant, but how did we get to where we have some adjoining properties are at 156 and 140, and then the one directly north is at 50.
Well, that was explained because that was based on the subdivision of the corner lot there, which
no, I get it was subdivided, but I still think, I mean, if it was,
well, it looks like it's only maybe 100 feet deep. I mean, it's not as deep of a lot as these other ones.
Gotcha. Yeah. Well, it just seems that
it does seem strange.
No, it just seems like you got one at 50 feet, and then you've got his property, and then you got one at 156, 140, 149. So,
yeah, it appears that corner lot is about 2/3 as deep, or almost a little bit more than half as deep as all the rest of the lots. So it's not really the same kind, I guess, same situation as, you know.
But, yeah, go ahead.
I know this is in Inglewood, and I think this is close to where the air park is. That's a park where it used to be.
Right across the street from Rosebank Elementary.
Yeah, so, yeah, exactly. And then, so a lot of the homes over here are they're very deep, far back off the street. So, I think a variance is probably warranted. I just want to make sure that the variance is appropriate for so that's my final thought.
Yeah, I would agree. I think something maybe, 50 foot is a lot to ask, but maybe something more in line with the 60 to 70 feet you see down the street there might kind of provide some kind of a stepping back of the houses. That helps in context when we do have kind of a intermediate house between different development patterns.
Is that going to leave enough space between the houses?
That's what I'm seeing. That's going to be pretty tough. So I don't know. Yeah. I mean, you wouldn't have as much of the backyard if you did that, I guess.
Sorry, and I just wanted to reiterate that there is a 70-foot platted setback. So it would, so anything,
setback.
you could grant a variance.
Right, but he still have to go
within
before the planning
yes,
commission to do
yes.
that? Okay. Did you,
So if we give him the 50 feet, he's got to go to the planning commission anyway and get that done, right? Okay. More thoughts? Anyone?
I know that it's not much of a backyard, but
It's more than the last case.
I mean, yeah, I mean, we're not considering that. Like, if you're gonna put another house in your front yard, you can do it by code. Have at it. Now, will that mean you have another house directly in front of your house? You know, if that's what you want to do, you know, so be it. But I don't think we need to necessarily. That's not enough of a hardship to give a concession for that.
Yeah, and I hear you on that. I wonder if it's not, if one of those adjoining properties and you're looking over and you're seeing two houses kind of squished together, I'm kind of trying to consider that too. There's definitely room. I mean, you could put it, and you're right, it's, those last two houses we had are uniquely together.
we got a lot of unique ones today.
Yeah,
Go back to boring.
No, it has not been boring today. So I'm really struggling with it. I don't. I mean, in one sense, lining up with the property to the north seems consistent, and then you've got these others at a further setback. So
Yeah, it's hard to, it's sort of hard to, you're basically got to pick your context. Who are you going to pick?
Yeah.
And I think that's the hard part. Like, which context is worthy of that? Why do we get to decide that?
yeah. Well, so what context do y'all think is the?
Well, I mean, if you want to split the baby, you could look at the platted setback of 70 feet. Could be an option. I don't know.
What's the hardship?
Details.
Great question.
Picky.
Yeah, well, that's a good question. I mean, I think it's an odd-shaped lot.
Yeah.
You really can't. The Unit A could not have been. You know, it would have to have a smaller footprint to go further back. It looks like an odd-shaped lot compared to what, from what I can see, from what. Yeah. Well, I mean, I would be fine with a 70. That's a 20-foot difference. I can't visualize. I rely on the architects. You're better visualizers than us lawyers. Is that 20 feet going to make it look? Is it going to kind of defeat the purpose of trying to get something that's not as anomalous?
I mean, I think anything that you build in front of the existing residence is going to look anomalous. I mean, we have a series of ranch houses along the street that are 150 feet back from the street, and then you got another one 50. I mean, it's an anomalous development pattern to start out with, and then it gets even more so when you add a house in front of this other house. So
I'm still looking for the hardship. Help me out here, guys.
I'm having a hard time as well.
I don't believe there's a hardship. I don't think aesthetically pleasing.
You can build on the existing lot as demonstrated by the fact that there's a building there. Is that?
And the existing residence is how far back? Why can't I find that?
It's 140.3 according to the survey.
Okay, thanks.
It's on page 160 of your packet.
Wrong. So if you were to build, they're requiring him to build 120 feet back, so you would be building right on top of the existing home, and then he'd have to remove the existing home.
Right. So let me ask this: if this lot if it were perfectly rectangular, Joseph, and it went all the way back like that, like the adjoining lot, then couldn't the original home have been pushed back further in the lot? And you could have
push back as far as you want to at that point. If you had more room back there, but it's as it is right now, it looks like it's about as far back as it could go. But yeah.
Well, that's what
Well, he
I
could
guess
shift
I'm
it
thinking.
over towards the other way, a little bit more behind it. But I'm still looking, someone needs to help me find my threshold issue is what's the hardship and what's the hardship that's not really self-imposed.
Yeah.
If you could, I'm not, and it's all Joseph's fault on that. He's the one that came up with.
I'll take the blame, but yeah, it's a self-imposed hardship, hardship. So
I think that's fair. I was trying to find a solution there, but I think that's a fair point. I don't see a hardship, frankly.
Your turn to weigh in.
But yes, you were countering it, Ms. Davis.
I'm going to let you remain.
I was going to remain silent. I've been looking. I don't see a hardship. I tried, though. I looked really hard for one. I don't see one.
I make a motion to deny the variance from the contextual setback requirement.
Second.
Okay. There's a motion to deny the request for a setback variance. All in favor, raise your hand, say aye. Aye. All opposed. So 5-1. Okay, next case.
What are we up to now?
Next case is 2022-47. This is a request for a street setback variance for property located at 627 Skyview in the RS 7.5 zoning district. Applicant is seeking a variance from the 37-foot contextual setback to build a front addition to an existing residence at the 33.5 foot line. We have the zoning map and an aerial picture of this neighborhood. Here is the subject property. And then the front portion of the home has some stairs to an entryway. And we have the applicant's site plan. Is anyone here in opposition to this case? Doesn't look like it, so if the applicant would come forward, please. And you'll have 5 minutes to be heard. Please tell us your name and address.
Hey, my name is Joseph Sharon. I live at 507 Skyview Drive, and have really enjoyed the Rolling Acres neighborhood over the last 3 years. We're also the owners of the property at 627 Skyview Drive and are requesting a variance on that property. Our goal with 627 was to create an improved space for other owners to enjoy the street as much as we do. This variance is for, this request is for a 3-foot 8-inch variance into the 36-foot 10-inch setback from the street. Upon purchasing this house, we realized there was significant water intrusion in the rear portion of the property, and we attempted to mitigate that with drain, and with a hope to improve the property space, we plan to minimize our impact, go into the back of the property in order to avoid interfering more with that watershed. So the home had an existing front porch, which I don't think I have a picture of it there, but I have a picture of it here. And so that's a little better. So
are you looking to enclose that? Is that what, because I couldn't figure out.
Correct.
Building on an existing front porch, and I couldn't figure out whether you were, what you meant by that.
To enclose the front porch.
To enclose the front. It's already there.
Correct.
Okay.
And the existing setback is from the front porch, but when we, in order to create like a symmetric gable, we plan to stretch the front porch footprint parallel to the street. And by doing that, we came out the depth of the original porch, which is 3 feet 8 inches. And so that's roughly what I believe is.
So it's all triggered by your wanting to enclose what's there and existing now?
Right.
Okay.
So that's the,
Okay. Any questions from the applicant? Okay, we'll close the public hearing and discuss. I will say to board members, I was almost going to put this on the consent agenda. I just wanted to make sure, it looked to me like that it was probably what the applicant wanted to do was build into enclose an existing front porch, but the building on an existing front porch is kind of, I wanted to clarify, so.
Could have saved this man 4 hours of his life if you'd done that.
Yeah. So
Wouldn't have enjoyed us. Now, what do you?
But I mean, I appreciate that it wasn't, because I understand the concern, because you're going, when you enclose it, I mean, we know that it's a front porch, but it looks less like a front porch because it's enclosed. So that changes how it fits on the rest of the street, so.
Yeah, right.
Well, I'll make a motion, we approve it.
Hardship being?
Well, the hardship being that there's already an existing front porch there. That's a good point. I just think historically that we generally viewed pretty favorably that if there's an existing structure there and closing it.
Yeah.
But, I mean, good point. I don't know. I mean, I guess the hardship would be that you'd have to tear down an existing structure and build it somewhere else on the property, if that amounts to.
He talked about some hardships in the backyard.
Oh, that's right, there was.
That prohibited him from building in the backyard because of water.
Yeah, there were some topography issues and water issues on the back, so.
What does that have to do with enclosing the front yard?
Well, I think it's what he's saying is he can't build on the back, that's not a suitable place to build.
I guess, I think maybe just to strike a compromise, I think maybe we approve it with some conditions, like maybe the type of screening. I don't know, like there's different things that we've done in the past to kind of meet in the middle. So I think maybe we approve it and put conditions on the type of screening that he has, and then if he makes any changes outside of this, that he has to come back. This is just me off the top of my head, you guys, I'm sorry.
Trees?
Yeah, put trees, right?
Trees.
Yeah,
That means we got to rely on the architect.
That's why I looked at them, but they're both like.
They're both staring at the
And then
screen.
Mr. Cole is looking at me, and I'm like.
It's only a 3 foot.
Yeah.
Yeah, it's only 3 feet.
It's de minimis.
I mean, right now, the setback line goes right through the middle of this porch. And so it's one of those things, like you can't feasibly build with the existing structure. You can't feasibly do anything to the setback line because of the existing structure.
Okay.
So.
But whatever, if you've got conditions, then a lot of times when we allow people a variance to build a front porch, we will ask them never to enclose it. If we're going to allow them to build it from the start, we've done that. But to me, this is already built, so I don't know, that wouldn't apply because we're doing kind of the opposite, but.
And I didn't realize, I'm glad that Mr. Newton mentioned that line goes straight through it. So I'm not as concerned. I can support it.
I'll second the motion that Mr. Pepper made then.
Okay.
I'm thinking trees.
Oh.
There's no trees in the front. Well, that would at least break it up a little bit in terms of sink.
Well, I will accept an amendment that the applicant agrees to plant a tree in the front yard.
At least I've gotten a nod from him, so I think it's going to be an agreed
Looks
to.
like a tree guy anyway, so I don't think it's.
I didn't get it on my small thing over earlier.
I'll just show you a picture of the backyard.
I understood.
He's trying to avoid taking down trees in the backyard. That's why he's doing it, right?
Yeah, well, I mean.
Planted 14 in the back.
14 in the back?
He's your new best friend.
It's also good for the water.
Yeah, that is good for them. Well, unless he's got a whole lot of, weeping willows, which will then.
Okay, we got a motion.
We got a motion and a second.
Motion and second, and he's going
All
to
in
do some
favor?
landscaping in the front with some deciduous nice trees.
He's going to plant a tree.
At least one.
Okay, at least one. He's all on board with that. All right, all in favor? Any opposed? So
I got my
that
tree
passes
today.
5-1, so.
5-2.
Thank you.
Don't plant a hackberry, because if Mr.
No
Law seriously
hackberries. If it's a
planted a
hackberry, you gotta come back.
Thank
he
you.
will rescind your application.
Okay, where are we now?
Last case. I believe we are down to our last case.
Is it really?
Yes.
Yes.
This
Here's the lucky
gentleman has
one.
waited all afternoon for this case, which is 2022-51. It's a request for variance from a street setback for property located at 149 Vaughn's Gap Road, located in the RS 40 zoning district. The contextual setback is 101.5 feet. Applicant is seeking to build to a 90-foot setback. Here's a zoning map of that area. Aerial photos. This is the lot as it exists, so it's currently unimproved, but there was a residence on it previously. And survey the property and the site plan. Is there anyone here in opposition to this case? I don't think so. So you will have 5 minutes to make your presentation.
All right. My name is Brad Van Rassel. I'm here on behalf of Bonardi's Architect, representing the owners, Timothy and Corey Creed. My address is 1011B North 6th Street. So we're requesting the reduction of 15 feet to the 105-foot contextual front setback along Vaughn's Gap in order to construct the owner's home, resulting in a 90-foot front setback. This reduction is necessitated by the hardship created by the combination of that diagonal sewer easement that kind of runs through the middle of that property, coupled with the contextual way that the front setbacks are determined. The 15-foot reduction we're asking for would bring us to the original front setback platted in 1953 and about to where that original structure sat on the lot. So we're not trying to push anything further than that. We met with our council person, Tom, on site on Tuesday. He had called us and was just doing his due diligence on behalf of some neighbors who just wanted some more information. And he met with us out there and responded to us by email that he feels comfortable with this location. He feels comfortable with that 90-foot setback. We also think it's pertinent to point out that this request would not make this the furthest one forward on this street by any means. 2 doors down, you have a house that sits 77 feet back from the property lines. So we're not gonna become that outlier that's way forward in front of everybody else. To specifically address the standards for variance, we believe this variance is permissible because the condition that creates this need is, which is, that diagonal sewer, and is not generally prevalent elsewhere. The conditions were not self-imposed. The financial gain is not the basis for this. This is to build the owner's home. This isn't development. They're not trying to sell it or anything. The granting of this variance will not be detrimental to the surrounding area and public welfare, especially since the house would still abide by the original platted front setback and remain in the general location of where the structure already sat there. And finally, the granting of this variance does not go against the purpose and intent of the zoning code. So in summary, the sewer easement coupled with that contextual front setback creates a hardship of the property, creating an overly constrictive building envelope, and that a variance from that setback of 15 feet would allow the home to be built in the location generally of the previous structure and to not greatly disturb any more of the lot or put it in jeopardy of that easement or encroach upon that.
So the home, just based on your survey that's been provided, it looks like the existing home's porch was actually in front of that 90-foot platted setback. Is that correct?
Yes.
Okay. So you're rebuilding this behind where the old home was.
Yeah.
Okay.
I had written down a question last night. Will the trees remain?
Yeah, that's actually Tom. When we were out there on site, he mentioned that this would come up, and we expressed to him as well that we're not, you know, it's a beautiful lot with a ton of trees. There's a few nice big ones in the front, and then most of the trees on the lot actually sit behind that sewer easement. So we're not even going to be anywhere close to it. We're not trying to take anything out. We're just kind of where the house already sat, we're going over that, and then there's some land that isn't in kind of, if you can tell from the survey, there's a lot of undulation going on, so we have a little additional wing from what the old structure footprint would have been, kind of down that, I guess that would be the east side of the property, but not disturbing any trees, trying to kind of fit it into the neighborhood rather than come in with a sledgehammer.
Sounds good.
I see you have curb cuts off both Lonsgap and Groom. Do you have garages off both of those, or what's going on? Okay, gotcha.
And both those curb cuts existed and currently exist today.
Okay, any further questions from the applicant? Okay, thank you, sir. Is there any opposition here? No opposition, okay. We'll close the public hearing and discuss.
We did receive some opposition from some neighbors in our packet.
Yeah, I saw that.
I just wanted to note that. That was received, but several of the things mentioned not building in front of where the old house was, which I think that Ace addressed that, and it kind of congruent with the long-established pattern in the neighborhood, which he's not changing that in terms of curb cuts or anything like that.
There's definitely a hardship.
There's definitely a hardship with the sewer easement, and yeah. You want me to make a motion? All right, I'll make a motion that we approve the variance as requested due to the hardship of the sewer easement and being further back than where the existing house was.
Second. Any further discussion about this one? Okay, all in favor, raise your hand, say aye. Okay. 5-0, you won.
All right.
All right, congratulations.
End on a good note. Thank you guys for being here for so long. That was a interesting and arduous one. I'm sure it was even more so for y'all sitting up there, so thank you.
Thanks.
Thank you.
Okay, we're adjourned.
More information.